This is what I do in my classroom. If you can hear me, clap once. If you can hear me, clap twice. Thank you. Good morning.
Good morning. Morning.
I am going to try to keep us kind of on track today. So we're going to get started. Good morning again. My name is Jessica Brown, and I am an assistant professor here at Vermont Law and Graduate School, as well as the director of our Center for Justice Reform. And along with the rest of the center team, we are really excited to be hosting this conference today. I think it's a really important opportunity to learn about and discuss second look legislation. Some logistics for those of you who are visiting our campus today. First, we will have students in our audience and also supporting the event today throughout the day. They have their name tags printed in green, so if you need any help finding anything or have a question, look for the students who will be at the table, or just look for the green name tags. But truly, any student here can help you, and they're all very friendly and lovely. So, if you walk through those doors at the bottom of that ramp and walk straight through the next set of doors, you will find yourself in an older wood creaky building. That is Debevoise, and if you turn left once you're in Debevoise, there are bathrooms there, and there's also the Yates Common Room, which is where we'll be going later this morning to get lunch. And finally, for anyone who is looking to get CLE credit for today, there are some forms on the registration table, and you can just grab one and have it for your records. I also want to acknowledge at the outset of the day, I will be offering thanks to many people throughout the day, but I want to start by thanking our cafe team, our IT team, and Buildings and Grounds for setting up the space, for putting out a lovely breakfast spread, and for truly making this day work, because it is going to be very much a hybrid affair. Yes, so thank you to all of them. If everything runs smoothly, it's all credit to them. If anything goes wrong, I'm sure it was an oversight on my part. So you will be hearing from me throughout the day, including as the moderator of our first panel starting at 10. So before that, I would actually like to introduce Dean of the Graduate School, Dr. Daniel Bromberg, and momentarily invite him up to make some opening remarks. Dean Bromberg came to Vermont Law and Graduate School from the University of New Hampshire, where he served as the Director of Academic Programs and then the Interim Director of the Carsey School of Public Policy. Dean Bromberg holds a PhD in public administration, and his scholarly publications include Calibrating Public Accountability, the Fragile Relationship Between Police Departments and Citizens in an Age of Video Surveillance, as well as other work focused on community resilience. Dean Bromberg has really brought some valuable experience and exciting ideas, and he is endlessly supportive of the programs and work of the Center for Justice Reform, and we feel very lucky to have him. So please meet and welcome Dean Dan Bromberg.
Thank you very much, Jessica. When I was asked to give some welcoming remarks, I figured I'd have like 30 seconds. And then I saw I had more than that, so I should probably write something down. So I did. So first, I'd like to welcome everyone to Vermont Law and Graduate School, our humble little community of South Royalton. We're thrilled to have you here. We're thrilled to have you join us on campus, which is a rarity these days, post-COVID and kind of getting back to the flow of meeting in person and learning together. So all of that is great to have. I want to start by thanking all of you for the work that you do. As we all know, many of our systems are flawed in many ways, and the work to reform those systems is essential to sustain our democracy. While I'm not a lawyer, I've spent a good deal of my time examining systems and system reform. Often it is the people who I work with, public managers who are on the front line of those systems, and they're on the front line of those reforms. Their lens is often more pragmatic, and their solutions are often less systematic. Structures and laws become fossilized, and public managers, often with legal counsel, find workarounds. And that's essentially what we see happening, right? There are these constant workarounds of these systems that are still buried underneath. True reform, however, must dig up those fossils, discard them, rebuild from the ground up. At the same time, we need to resist the temptation in our reforms to default to the ease of technological, algorithm-driven solutions. Data should inform discretion. Data shouldn't replace discretion. While I recognize the challenge of placing trust in public officials, the empirical findings often show that trust enables better service provision. So we need to enable professionals to do their jobs with thought and care and hold them accountable to do so in an ethical manner. And that's essentially what our findings in the public management side find on a regular basis. And my guess is, while I don't study courts, they would transfer over reasonably well. So in an attempt to fill at least a little portion of my time here, I hope I'm not steering us too far off course, but I would encourage you to think about some of those ideas as you guys are talking today. I want to thank you all for coming, and I really do hope you have a wonderful day learning from each other and sharing all of your stories and making progress on this important reform. So thank you.
Thank you so much, Dean Bromberg. So as I mentioned, I'll be, in a few minutes, I'll be moderating the first panel. But before we start it, I would like to talk about my hopes and intentions for today. I became the director of the Center for Justice Reform this past summer, following in the footsteps of our founding director, Professor Bobby Sand, Professor Stephanie Clark, who was the director of the program for the past 5 years and who I just saw walk in, and I have to do it. When you see her today, please wish her a happy birthday. And I also want to mention our former assistant director, Alana Ojibwe, who was critical to making the Center for Justice Reform what it is today, and who fortunately is still doing this important work with the National Center on Restorative Justice. The Center for Justice Reform was founded on the pillars of restorative justice and justice reform, and under the stewardship of Professor Sand and Professor Clark, the Center for Justice Reform developed a robust restorative justice degree program, which I strive to help continue to grow and move forward. Stepping into the director position, what feels more open to interpretation is what impact I want the CJR to have in the realm of justice reform. Fortunately, I'm not figuring that out on my own. The rest of our team includes our founding director, who I've already introduced, Bobby Sand, our associate director, Professor Jill Martin-Diaz, who leads the Center for Justice Reform Clinic, which provides immigrant defense services and is increasingly expanding to provide post-conviction criminal defense services. Partnering with Jill in leading the clinic is Professor Brett Stokes, and the clinic has been fortunate to host this year's Vermont Poverty Law Fellow, Maya Sukazaki. The newest members of the CJR team, who have quickly become the backbones of our offices, include our Burlington office-based office assistant Osvaldo Vieira Marciatu, and our South Royalton-based project coordinator, Cora Allison, who deserves the biggest shout out for working so hard to pull today together. During the transition to the current iteration of the CJR team, one of the things that we did was come up with a CJR mission statement, which says, the Center for Justice Reform at Vermont Law and Graduate School exists to transform the ways communities engage with each other, respond to harm, and pursue justice. We advance this mission by empowering VLGS students to think restoratively while equipping them with knowledge and skills to be agents of change. By way of a little bit more background about me, for those who don't know me, before I joined the VLGS faculty, I was a public defender for over 20 years. And at a couple of different stages in my public defender career, I was the managing attorney for the office in which I worked. And I think that I was at my best as a public defender manager when I realized that my purpose was to figure out how I could best support every person in every role in my office to best serve the people who we represented. We call that client-centered, a client-centered approach. How that translates for me as a professor and as the director of the Center for Justice Reform is right there in the CJR mission statement. My purpose is to empower our students to think restoratively and to equip them with the knowledge and skills to be agents of change. So given my career background and the continuing focus of my work, I'm sure it does not surprise anyone to hear that I think that if the state of Vermont is serious about addressing our rate of incarceration, and particularly the rate at which we disproportionately incarcerate Black, Brown, and Indigenous people, we need to be looking at all possible ways to reform our criminal legal system, including passing a second look statute in Vermont. So my hopes and intentions for today are that we are all arriving here with a growth mindset, open to learning about second look legislation and modeling for each other, and particularly for our students, what it means to be agents of change. Today's conference is going to be a hybrid affair, as I've mentioned. For better or worse, much of our engagement in the world these days is now virtual. But today, I believe it is for the better for us because it allows us to hear from people who we wouldn't otherwise hear from. And it allows people to join our audience who wouldn't otherwise be able to join. So starting in about 15 minutes, our first panel is going to be mostly virtual. Later today, we will have an in-person discussion facilitated by our National Center on Restorative Justice team. I'm thrilled that they're all here with us today. And for those of you who are watching the live stream, there will be an option for folks joining online to participate in a facilitated online discussion. That will be followed by our keynote speaker joining us virtually. And then our last panel of the day will also be a hybrid affair with a couple of people here in person and a couple of people online. So now we're ahead of time. So we're just gonna take a little break and I'll check in with Brian. And as soon as we have all of our online folks for our first panel, we'll get started. Thank you so much for being here.
Hey Nazgul, how you doing?
Because our panelists are all here. I'm very excited. It's nerve-wracking standing behind that computer setup over there and waiting to see the faces pop up on Teams. But they're all here, and we're so delighted to have you. This first panel is really going to be foundational. We have 4, and we're actually going to be joined by a 5th person who are really doing the work around Second Look for 2 major organizations right now. I'm going to tell you who they are, but I'm then going to start by having them introduce themselves. And the way the panel is going to work is that after they introduce themselves, I have prepared some questions for particular panelists, although I will certainly invite every panelist to comment at any point if they have something to add. We're going to be juggling a little bit this morning because someone who we had hoped to have and weren't sure we would be able to join us is going to be able to join us, but he's out in California and he can't join us till 11, and that is Dr. Robert Kinshreff. Gosh. I'm going to make sure I know how to say his name before he joins us, who is from Harvard and is going to talk about the brain science that is relevant to this issue of Second Look. So we're excited that he'll be able to join us a bit later. And we certainly will save time for questions from our audience members who are here in person, as well as those online. Our program coordinator, Cora, will be monitoring the Q&A online, so if you have questions and you're watching the live stream, please feel free to enter them into the Q&A. Who we have here now, next to me, first of all, is Alexandra Bailey, and then on screen, our attorney, Becky Feldman, and Dr. Nazgul Gandnoosh. All 3 of them are from the Sentencing Project in Washington, D.C. And then to shake things up a little bit, we also have attorney James Ziegler, who is from the Second Look Project, also based in Washington, D.C. So to start, I am going to ask each of our panelists to please introduce yourself and give a brief overview of your work as it relates to the criminal legal system and in particular Second Look legislation. And so, Alexandra, let's start with you.
Hi, everyone. I'm so incredibly pleased to be here. My name is Alexandra Bailey. I use she, her pronouns. I am the senior campaign strategist at the Sentencing Project. I am also a directly impacted family member and a 2-time survivor of violent crime, with one of my perpetrators serving a life without the possibility of parole sentence. I have been impacted by our criminal legal system since I was a little girl, and have shaped my life's work around either electing people who were going to do something about it or fighting to change laws that affect the Black and brown communities that I grew up in and who I saw disappear into our system.
Thank you. Attorney Feldman, can you introduce yourself, please, and tell us about your work?
Yes, thank you. I'm Becky Feldman, and I'm the director of the Second Look Network. And before my time here, I spent 15 years at the Maryland Public Defender's Office in their post-conviction division. So my job was to get people out of prison. And we did that through a variety of ways, but mostly through the Post-Conviction Procedure Act. But also through other creative lawyering ways. And then I went to the state's attorney's office for 2 years to create their sentencing review unit in Baltimore City. That went until the end of 2022. And then I've been with the Sentencing Project this past year, creating the Second Look Network, which is a network of litigators across the country who are doing second look type litigation so that we can share resources, training, and be supportive of each other in this work. Thanks.
Thank you. Dr. Gandnoush, please introduce yourself and tell us about your work.
Sure. Hi, everyone. I'm Nazgul Gandnoush. I'm co-director of research at the Sentencing Project. I have the great honor of working with Becky and Alex. I, a couple years ago, wrote a report about second look reforms and have been very excited to see this growing movement. And so my role is to help connect the advocacy and advocacy community and lawmakers and practitioners to research that helps to make clear why we should have these kinds of laws. And in terms of my background, I'm the kind of doctor that can help with citations rather than any medical problem. So I did a PhD in sociology at UCLA, and as part of that work, I was working closely with people serving parole-eligible life sentences and had a chance to understand the impact of extreme sentences on family members and loved ones, and also got a close view of how hard it is for people to get out of prison with the mechanisms that exist beyond second look, so such as through the parole process. And so I'm very excited about the possibility of second look reforms that allow for a more meaningful consideration of when people have served enough time behind bars.
Great, thank you so much. And last but not least, Attorney Ziegler, please introduce yourself and tell us about your work.
Hi, my name is James Ziegler. I'm the founder and co-executive director of the Second Look Project. We're an organization based in Washington, D.C. that works primarily on behalf of people who are eligible for resentencing under, or eligible to pursue resentencing under D.C.'s Second Look law, as well as D.C.'s compassionate release law. Our work is primarily direct representation of eligible people, although we also provide training and support to other practitioners in the jurisdiction, and have worked to hopefully kind of distill, what we believe to be DC's kind of successful experience with Second Look, so that it can serve as a roadmap to other jurisdictions. I got into this as a solo practitioner taking court-appointed indigent casework back when the very first iteration of DC's Second Look law passed, which was in 2017. It went into effect. And so I put my name on the list to take these cases when it was a brand new thing and no one knew anything about them, and ended up being one of the first lawyers to kind of actively litigate one of these cases, and found out that I really liked them, and it became kind of the focus of my practice. In 2019, was able, with the support of some of our funders, to start the Second Look Project with the hope of kind of institutionalizing and expanding the work that can be done on behalf of our client population. And so we have continued that work over now 3 iterations of DC's law, which I'll kind of explain at some point today, the process by which our law is developed. But that's the work we do here in DC, and we hope that it may be useful to folks who are trying to do the same thing.
Thank you. That's actually a perfect segue to start our discussion. And I just realized, I asked our panelists to introduce themselves, and there might be folks who've joined online just now as we started this panel, so I just want to reintroduce myself. My name is Jessica Brown. I use she, her pronouns. I am an assistant professor here at Vermont Law and Graduate School, as well as the director of our Center for Justice Reform. And before I started working here at Vermont Law and Graduate School, I was a public defender for about 24 years. So with that, I will continue by asking, Attorney Ziegler, it would be great if we could start with you. Can you explain to us, what is second look legislation? When we use that phrase, second look legislation, what do we mean? And can you describe an example, in your case, Washington, D.C.'s law that you've referenced a couple of times, of what that legislation looks like, what it includes, what it encompasses in your jurisdiction.
Sure. So I think when we talk about second look legislation generally, we're talking about any kind of mechanism that can be, legal mechanism that can be created that allows people serving sentences, and especially really lengthy sentences, an opportunity to have someone kind of review that sentence in light of new facts or an expanded understanding of the old facts to determine whether or not the original sentence is still necessary or just, and really whether or not this is someone that still needs to be in prison. And so that could be a judicial review mechanism like the one we have here in Washington, D.C. It could also be a mechanism that expands opportunities for parole or review in front of some other administrative body. The big picture and the important thing when we talk about this stuff is just creating some way for people who are incarcerated to get a second look and have someone, decide through a proper lens, is this someone that we need to keep incarcerated? Because the truth is that we have so many people in our prisons who don't need to be locked up anymore. And if we look at those people kind of honestly and carefully, I think that's a conclusion, a lot of people would reach, even people who are not, who would think of kind of ideologically sympathetic when we talk about the kind of criminal justice reform movement, because there's just a lot of people out there who don't need to be locked up that are. So in DC, like I mentioned, our mechanism is a judicial review process. It allows someone who is currently incarcerated for an offense committed before they turn 25 and who has served at least 15 years in prison to file a motion with the trial court seeking a sentence modification. And the judge has to make, the petitioner bears the burden of making two showings, and the judge has to find that a person is not a danger to the community if they're released, and B, that the interests of justice warrant their resentencing. And if the petitioner makes those showings and the judge makes those findings, the judge can then reduce their sentence. Our law does not explicitly require release in the event that someone's motion is granted, although that's the way most judges have interpreted it. And I'll backtrack a little bit just to kind of talk about the development of our law. It went into effect in 2017. Our law is called the Incarceration Reduction Amendment Act, or IRAA. In 2017, as a way of kind of codifying and reflecting the Supreme Court's line of cases that entered in Miller and Graham, were saying that mandatory life without parole for people who were juveniles or children when they committed their offenses is unconstitutional. So our law was originally only for people who were under 18 at the time of their offense and had served 20 years and were not yet parole eligible. A couple years later, it was tweaked slightly to allow people who were under 18 at the time of the offense and had served 15 years, so they reduced the time served requirement, to petition for resentencing regardless of whether or not they were eligible for parole. And that was because it had kind of, legislators and stakeholders kind of realized that there's a lot of people who had gone in front of the parole board who probably should be released but weren't really getting a fair shake from the parole commission. And the important thing I want to add to about our law is that there are no category of offense restrictions. I think there's a kind of political salability issue when you talk about getting this stuff passed, and a lot of times there's an incentive or a temptation to kind of exclude sex offenses or exclude first-degree murder, exclude the more serious stuff. That's a tricky question. Obviously, we are lucky that we have not had to do that, and so our law does not have any of those exclusions. But the third iteration of our law came into effect in 2021, which expanded the age at the time of the offense eligibility pretty dramatically, from under 18 to under 25, in an attempt to kind of make the law align more with what we know about kind of developmental maturity and brain science, and when people really, the kind of impetuosity and impulsiveness and poor decision making of youth really tends to phase out, which we believe to be in the kind of mid-20s. And when that went into effect in 2021, it expanded our eligible population from about 100 to about 600. So that was a big implementation challenge. It was a big victory, and that's kind of where we are now. We've had about 200 cases, 200 people released under our law, the overwhelming majority of whom were serving sentences for either murder or serious sexual assault. And we've had about 40 cases denied, 30 or 40 cases denied. So about an 80 to 85% success rate, which is, I think, much better than we ever thought at the outset we were going to see. And we're real proud of how that's gone.
That's incredible. Thank you. That was really informative. I want to turn to Alexandra now and ask if what other jurisdictions in the country have passed second look type legislation, and sort of, are there other models? You know, Attorney Ziegler described the model in DC, but are there other models of this legislation that you've seen around the country?
The good news is that the movement for second look, quite frankly, is the sentencing project can barely keep up with the demand for drafting of second look laws. As our senior campaign strategist, I'm the one who spends the time in the state legislatures across the country, and there are a multitude of states that have active bills, and I can go through where all those bills are at by individual jurisdiction, but the laundry list is Rhode Island, Vermont, Massachusetts, New York State. I just got back from the Tampa Bay Justice Summit, where Republican Eliana Garcia announced Florida's second look bill. Nebraska has an active bill. Michigan has an active bill, and California just passed a second look provision 2 or 3 days ago. I'm sorry, I have to go back when Stanford emailed me. But within like sort of the last 72 hours this week, that bill passed. So at this juncture, and that's just sort of straightforward second look. There have also been a number of bills to either reinstate or modify parole, particularly for seniors. New York has 2 bills. One is Fair and Timely Parole Act. The other is the Elder Parole Act. Pennsylvania has a bill that, clap to FAM, just passed out to help the elderly who are incarcerated. We also are focused on domestic violence survivor justice acts, with our primary focus right now being on Oklahoma, which has the highest rate of incarcerated women, and according to the University of Oklahoma, 65+% of the women incarcerated there were victims of domestic violence within the year of their offense, and they are all serving lengthy sentences as well. Resentencing for the sake of justice at this juncture, and a look at the system writ large, is something that many states of all political stripes are seeing, not just as a moral issue, but also as a fiscal concern, as the populations grow elderly, and Vermont is in that category. So we keep busy. Oh, Maryland. So sorry, Becky. Maryland. Virginia, sorry. I'm just going to pipe in with states as they come to me. I need more coffee, clearly.
Dr. Ganush, I would like to turn to you now. When you introduced yourself, you talked about connecting research to this legislation. Tell us about sort of what kind of criminal legal system data and research you provide in support of second look legislation, and why that data and research is relevant to consideration of second look.
Sure thing. So I usually think about this in sort of three categories. And so first there's research related to public safety. And the way that we framed this at the Sentencing Project and presented is that these reforms, like Second Look, that scale back extreme sentences, they're not only at odds with promoting public safety, but they actually help to promote public safety. And I'll explain what I mean. And so we think of extreme sentences as being counterproductive to promoting public safety. And so that's because the short answer to that explanation for why that is because extreme sentences don't help to prevent crime, and they get in the way of making much more effective investments to preventing future victimization. And so the reasons that they don't help to, that Second Look reforms are not at odds with promoting public safety is because when you look at research on how when people engage in criminal activity, they typically do that when they're younger. And people age out of crime. Even people who commit very serious crimes, even people who commit a lot of crimes, as they get into their 30s, 40s, and beyond, they're much less likely to do so. And so research on recidivism makes that very clear, showing that people who serve longer sentences when they're released from prison, they're older, and in particular, people who are released from prison after life sentences have some of the lowest recidivism rates. A study looking at this in California of people who had served parole-eligible life sentences described this population as having a minuscule rate of recidivism. And this is something that if you talk to any researcher, regardless of where they land on the question of whether or not they support Second Look reforms, they will agree with this fact that people that serve the longest sentences have the lowest recidivism rates. Another reason that long sentences are not effective has to do with the question of whether long sentences send an effective message to deter other people from criminal activity. It would make intuitive sense to think, well, never mind the people that we're going to hold behind bars for a very long time. Let's think about how if we hold them accountable in this way, it can help to discourage other people from criminal activity. And the research on that question is also clear that very long sentences are not effective as deterrents. So Daniel Nagin, who's a professor at Carnegie Mellon University, is an expert in this field, and he's surveyed the research and done his own research and says that there's very limited deterrent value to keeping people in prison for multiple decades. And the reason for that, if you look into it, is because people generally don't expect to be caught, and that's actually not an unreasonable expectation. Many crimes are not reported. For the most serious crimes where they are reported and investigated, even there, you don't have a very high clearance rate. A lot of crimes go, police officers are not able to arrest someone for the offense, including for murder. Doesn't have as high of a clearance rate as we would like to see. It's roughly, about 2/3 of those crimes are solved. And so people just are not as worried about the extreme sentence that they might face because they don't expect to be caught, or they're committing the crime under the influence of serious drugs or alcohol use. And so for that reason, threatening people with an extreme sentence is not an effective deterrent. But doing other things like treating that drug or alcohol problem, making sure that everyone has access to treatment, doing things like the criminologist would say increasing the certainty of punishment instead of the severity of it would help to be a more effective deterrent. So that's the deterrence issue. And then I also mentioned that, investing in extreme sentences means that you're incarcerating people into old age when it gets very expensive to incarcerate them because of their higher medical needs. And again, this is a population that doesn't pose a serious public safety risk and yet is very expensive to hold behind bars. And so what could we be doing better with those limited resources that we have for investing in public safety? So that's the public safety argument. There's also a really important racial equity argument, and this is something that I think a lot of researchers have only recently begun to have a good sense of. So we know that there are a lot of racial disparities in who's incarcerated overall, but actually all of these disparities, racial and ethnic disparities, get worse when you look at the longest sentences. So for example, the US prison population is 14% African American. If you look at the total US population is 14% African American. If you look at the prison population overall, nationally, it's 33% African American. If you look at the population that's served at least a sentence of 10 years or longer already, it's 46% African American. So you see how the proportion of people who are Black increases with sentence lengths. And so that means that, and the National Academy of Sciences recently put out a report on how to reduce racial disparities in incarceration and in criminal justice. And they identify second look reforms as a way of bringing more racial equity to the criminal justice system, because it helps to alleviate these very extreme sentences that people of color, and in particular Black Americans, are most likely to face. And then just the last point that I would make is, this is the third part, that scaling back extreme sentences through second look reforms is critical to ending mass incarceration and to having what we can actually call a criminal justice system, to making it more just. And that's because a lot of people don't realize this, but if you look at the prison population overall, it's think about what percentage you think is there for a drug offense. I ask a lot of people this question. Think about what percentage of people in prison you think have a drug conviction as their most serious crime. What percentage would you guess? And I would love to hear from the audience about this. Feel free to shout it out.
Yeah, shout them out.
Someone said 50%. Any other guesses? 60%? 65%?
Great. Thank you. The answer is 17%. The overall, when you look at people who are in prisons, it's a minority who are there for a drug conviction as their most serious offense. And that's why the great progress that we've made, not enough, but it's been significant in scaling back the number of people in prison for nonviolent drug offenses, it can only take us so far, because the majority of people that are in prison are there for a violent offense as their most serious crime. And so we have to be able to recognize that we're sending too many people to prison, and we're holding them in prison for way too long, even for violent crimes. People need to be held accountable, but holding people behind bars for 20, 30, 40 plus years for a violent offense, what it does is it creates a really large population serving life sentences, for example. So nationally, we know it's 1 in 7 people in prison is serving a life sentence. In Vermont, it's 20% of the prison population is serving a life sentence, higher than the national average. And what happens is, not just in terms of, really large, growing elderly population serving these extreme sentences, but it skews our whole understanding of the sentencing structure. It makes a sentence of 5 or 10 years for a property crime seem like not a big deal when you have so many people serving life sentences, when even those 5, 10-year sentences are significant. So that's why the Model Penal Code, for example, the American Bar Association, they've endorsed second look reforms. And part of the reason for that is that the scaling back extreme sentences can help to rationalize the entire sentencing structure and help us to get a better sense of what's an appropriate sentence for crimes across the board.
Thank you so much. That was so informative. And I'm going to come back later definitely to this topic of public safety and recidivism. But for now, I want to turn to Attorney Feldman. When you introduced yourself, you shared with us your trajectory as an attorney, having worked as a public defender in Maryland, and then for the Baltimore City State's Attorney's Office before joining the Sentencing Project. But the common thread through your work is supporting individuals or their lawyers who are seeking release from extreme sentences. I feel like I read in your bio that when you were with the state's attorney's sentencing review unit, you successfully supported the release of more than 50 individuals over a 2-year period. So my question to you is, in that role, when you were working for the state's attorney's office, why did the Baltimore City State's Attorney's Office even have a sentencing review unit? And what were the factors that the state's attorney considered when deciding whether or not to support releasing someone from an extreme sentence? Whoops. We can't hear you yet.
Becky, you're muted.
I can't believe I did that. Okay. Thank you for the question.
We need more coffee.
I know, and I have it here. Okay, so I went to the state's attorney's office, which I never thought would be my career trajectory, but it was because the then Baltimore City State's Attorney's wanted to create a sentence review unit to release people who have been incarcerated for a lengthy period of time and no longer pose a public safety threat. And the reason, and I actually pulled up our talkers from 3 years ago, and one of the reasons she did it is she said prosecutors have historically played a role and contributed to the epidemic of mass incarceration and racial inequity in this country. And we have a responsibility to right that wrong. And so that was a pretty dramatic statement to be made. And there have been efforts across the country to enact prosecutor-initiated resentencing, where prosecutors are taking the responsibility of looking back at these sentences that were imposed years ago based on their recommendations a lot of the time and trying to course correct. But I would say it's not a super popular movement yet, but I think it's important for prosecutors' offices to take that responsibility. Another reason that we created the unit was, at the time, this was 2020, it was COVID. We had to empty our prisons as much as possible. That made sense, and our detention centers. So this was another way to accomplish that. And lastly, at the time, and I think this is still the case today, is there was a report issued that Maryland incarcerated more Black and brown people than anyone in the country. And that was a really surprising statistic for us in a blue state. And so it got a lot of attention. And so this unit was created to try to address those wrongs. So some of the things we looked at a lot of things, and our criteria was if you were convicted as a juvenile and have served at least 20 years, and if you were at least 60 years or older and have served, I think it was 25 years. So we focused on those two populations first. And so we looked at things like what was the crime, obviously. We reached out to victims' family if they wanted to participate, and asked them for their opinion and provided resources to them. We looked at how old were you at the time of the crime? How long have you spent in prison? What have you been doing in the past 20, 30 years? What does the re-entry plan look like? We even looked at things like how strong was the evidence at the time? Is this something we would have prosecuted today? Considering the changes in forensic evidence in, say, jailhouse snitch cases, like Baltimore City does not prosecute any more jailhouse snitch cases, believing they are entirely unreliable. And so there were a lot of times where I recommended a reduced sentence because the evidence was weak, or this would not have been a sentence we would have recommended 30 years ago. So yeah, that was and it was very successful. It was publicly popular because in Baltimore City, unfortunately, almost everyone knows someone in prison. It's really bad. So we got hundreds and hundreds of letters from people asking, please help my son, my brother, my nephew, my sister. So it was very popular. Unfortunately, my boss lost re-election, and so we have a new state's attorney in Baltimore City now, and I don't know to what extent that program will continue. Right now, it's not, but I'll remain hopeful that it does continue. And if I could, I wanted to answer your question about what second look laws are out there already, and I actually have a list. And so most of them are age-based. Meaning if you were 18 or under 18 at the time of the crime. So that's Maryland, New Jersey, Delaware, and served at least 20 years in prison, you have the right to a hearing in front of a judge. The best second look law, hands down, is DC. So if you're looking of what to model, call James Ziegler and his team. It's under 25 and served at least 15 years. And they also have a geriatric provision, which is 60 years or older and have served at least 20 years. And I think there's a couple of exceptions to that, but that one's the best in the country by far. let's see, who else is out there? So California is doing lots of cool things. They haven't done anything as broad as what DC has done, but they enacted a ton of terrible laws in the 90s. Now they're rolling them all back and giving people who were convicted under those terrible laws the right to resentencing. So they probably have 9 different second look laws based on, say, the 3 strikes, the infamous 3 strikes law in California. There are hundreds of people serving sentences for things like breaking a window. They got a life sentence for that because that was their 3rd strike. So now they can go back to court, get resentenced. Hundreds and hundreds of people have been released under what California is now doing.
Thank you for all of that information. These have been such informative, great answers. I want to talk about safety and recidivism because Dr. Ganush brought this up. And when Attorney Ziegler was speaking, I was thinking about this question as well. So to the extent that you can, and I open this up to any of the panelists, for example, Attorney Ziegler, of the numbers that you mentioned of successful petitions, I think you said you have about an 80 to 85% success rate. Do you know what the recidivism rate is for any of those people who got released? And similarly to any of the panelists, can you kind of talk about, because this is a concern that opponents of second look legislation bring up, which is, is this safe? And so can we talk a little bit about recidivism rates?
Sure, and that's something we're always eager to talk about because I think our recidivism rates have been really pretty good in DC. And there's a couple of kind of asterisks to attach to all this, which is that we've had 200 people released, but that has been a kind of gradual process over the last 4 or 6 years, I guess. It's been 6 years since we started doing this. The first release was in 2018, so that was 5 years ago, I guess. But so there are fewer people who have been out for 5 years than have been out for 1 or 2 years. So we're still, there's an asterisk there. But we have, I think, probably 10 or so, maybe a couple less than 10, but my estimate is around 10 people who've been rearrested for new law violations of any kind. With most of them having been either drug possession or gun possession, but not involving any kind of violent conduct. We have had a handful of rearrests for new violent offenses, but I think total new law violations alleged, and many of these have not been adjudicated yet, we're probably at around 10. And given the number of people that we are talking about, that is I am confident, is a much kind of lower recidivism rate than you see from the kind of normal population of people released from prison. And it's not hard to understand why that is, because people released under our second look law are released after a kind of thorough and intensive review by a judge to determine whether or not primarily this person, has matured and grown to a place where they can safely be released. Whereas we have determinate sentencing in DC and have since 2000. So people get released at the end of their sentence, regardless of what they've done with their time in, no matter how much programming they've done and how much they've improved and grown, or how much trouble they've gotten into and how little growth and development they've shown. When you hit the end of your sentence under our determinate sentencing regime, you're out. Whereas here with our second look population, you're dealing with people who have been kind of vetted by a judge for kind of fitness for release. So you see a much lower recidivism rate than you do with kind of the general population of people coming home. But it's we are proud of those numbers. The other thing that I think plays a big role in that is the development of kind of strong reentry support networks for the folks coming home, because there's a lot of opportunities to not do the right thing. And so I think our community has done a real good job. And the guys that have come home, I say guys because our population has been all men, but the people that have come home have been really supportive of one another and making sure that kind of everyone, is successful.
Thank you. Does anyone else on the panel want to sort of talk about that, the safety concerns or recidivism?
Well, from a very sort of practical standpoint, I'm also a former elected official. I was the commissioner for 2F08. I also chaired public safety for my commission. And so I was sort of very regularly in contact with MPD, which is our police force, as well as the mayor's office for violence interruption and dealing with serious issues of homelessness and mental health and people who did a lot of in and out of the system. There are a couple of sort of just very sort of solid numbers. So obviously we track via commission where our violence rates are. At the beginning of my term, I asked the mayor's office to assign a violence interrupter to my district because we had a number of issues going on, including shootings and other things of that nature. By the time I left office, we were down by 4%, thanks to our violence interrupter who was formerly incarcerated. In addition to that, I think it's really worth noting how the people who have returned have really added to our community. You'll hear from Warren Allen later today, who's actually our fellow at the Sentencing Project, who is an IRA recipient. Joel Caston, when I was a commissioner, decided that he wanted to run to be a commissioner to represent DC jail, DC's prison. And we actually, the commissioners of Washington, D.C., after speaking with him, did a massive movement to allow him to be on the ballot. He was elected. He is still an elected commissioner. He's an IRA recipient. The people who've come out, I have the pleasure of knowing many of them, and I feel that we made a very, very good choice for our community.
Thanks, Alexandra. And Attorney Feldman, I saw your hand up as well.
Yes, I just wanted to talk a little bit about what we did in Maryland, where we had a huge Maryland Supreme Court decision in 2012, which allowed for people who were still serving sentences prior to 1981 as a result of a jury trial to have a new trial. And so we managed to get 200 people out of prison. They were all convicted of either murder or rape, or both, between 2012 and 2018. And I've been tracking recidivism rates of that population, and it is still, as of today, under 4%. 7 of the 200 either violated parole or probation or got a new charge and was convicted of a new charge. Of those charges, only one was a crime of violence. The others were not drug-related, firearm-related. And then there were a few that were just technical violations for parole or probation and were violated. So we're really thrilled with that number. Obviously, we always want 0, but it's an extremely low number considering the seriousness of the offenses and that they had been incarcerated between 30 to 60 years and were released. And a huge piece of that, as James Ziegler talked about, is reentry support. We had grants that provided social workers for every single person who was released to make sure they had a stable release plan. They got whatever resources they needed. We helped them with things like getting their IDs, getting them apartments, getting them into treatment if that's what was needed. Even just navigating systems. We got them bus passes, like all kinds of things we probably don't think of and take for granted. We did our best to provide those services to them and did that for a number of years. There was a lot of follow-up care as well. So we talk about this project a lot in Maryland because it was just this random court case that happened that nobody was expecting. And so we have this natural study now of what happens when 200 people are released, after 30 years and what can be done. And it's been very successful.
Becky was
I would
picking
just-
people up like off the sidewalk. She's awesome.
Dr.
Um,
Ganush,
just-
come on in.
Thank you. I worked really hard to prevent myself from showing any slides during this conversation, but I did prepare some slides, and I shared that.
Don't hold back. Feel free to share.
But I did want to just say that if those slides get circulated, I have a picture of the folks that were released as a result of this case that Becky was talking about. And when you look at that picture, you see a group of people that are very old. And, and I think I can show people charts of criminal careers, the age crime curve, recidivism data. That can help explain things numerically. Meeting folks like Warren Allen that you'll meet later will help to give you a sense of the kind of people that we're talking about. But also seeing some of these photos of individuals that are released, in their very old age, gives you a sense of why these are individuals that you would not expect to be a public safety risk. And so just to add to what's been shared already, we've talked about recidivism. I think I mentioned, or I'll mention now, that there's research that looks at criminal careers. So, when people start committing crime and when they stop. And based on that research, there's evidence that criminal careers typically last under 10 years. There's a bit of a range to it, but typically people, when they start, they don't keep going after 10 years. And there's just this quote that I have from these academics. Their names are Lila Kazamian and David Farrington. And based on their research on criminal careers, they say the harsher sentences imposed on individuals convicted of violent offenses may serve a retributive purpose, but they're not justified by recidivism data or our analyses of residual criminal careers. So there's really no doubt among people who are researching these issues and people who are close to these issues that this is not a threatening population, and the arguments that can be made against releasing them do not have to do with public safety. They have to do with other things. They have to do with the fact that we're still mad about what they did. And I think there it's important to consider that just two additional things. One of them is that if you talk to people who work as correctional officers and you ask them who's the population in the prison that you think that you would feel safest being around, that you think brings the most stability to the institution, they will always tell you that that population is people who've served the longest sentences, people who've been there for the most serious offenses, because they're older, much more mature. That's the population that sometimes correctional guards are rooting for and want them to get out, but sometimes they also just want them to stay because they're such a good force on prisons, and on the environment within these institutions. And then just a final point that I would make is, in terms of, society being rightly still mad in some cases about the harm that these individuals have caused, it's important to recognize that in many of these situations, the victims do not necessarily still want their continued incarceration. The survivors of the crime that when we've seen second look cases come up and people petition for resentencing, there are some situations where there's opposition from victims, certainly, but there are also some situations where survivors of individuals that have, family, loved ones of individuals that have been killed, for example, or even individuals who've been sexually harmed, they forgive the individual, they've moved on, they do not want the person to continue to be incarcerated. So there's really a broad range of responses from people that have been directly impacted by the crimes themselves.
Well, you really set me up for my last prepared question perfectly. Thank you. Which is that we need to talk about survivors, right? We need to talk about victims.
Absolutely.
Because here at the LGS, the Center for I've mentioned earlier, one of the pillars of the Center for Justice Reform is restorative justice, and we now offer degrees in the study of restorative justice. And restorative justice, central to the concept of restorative justice, is that it is informed by the needs of the harmed party. And so my question is, how does second look legislation take into consideration the needs of the people who've been harmed by the crimes committed by the people who are serving these extreme sentences. Because certainly there are people who are opposed to the idea of second look, in part based on fairness, right? Is it fair to have told someone that this person's going to go to prison for the rest of their life and then change that? So yeah, I would love to hear all of you speak to this question about how second look should be informed by the needs of the harmed parties.
Well, if everybody doesn't mind, I do want to sort of jump in here. And I'm sorry, this is where I get a little emotional because I'm going to talk about my victimization. The first time I was perpetrated against, it was violent and sexual, and I was a child. Not a teenager, not an adolescent, a child. The person who committed that offense against me was a family member who is now serving a life without the possibility of parole sentence, where my family is originally from, Louisiana. And so that is a state where hope is completely non-existent. Through a restorative justice process, I learned quite a bit about the person who tore me apart for 15 to 20 years, arguably. A lot of intense therapy needed. What became very clear to me, even when I was young, was that what I actually needed at my time of victimization actually was not available. I was told that the monster was going to go away and I was going to feel better. For 15 to 20 years, I can assure you that didn't help. When I talked to him, what I learned was about the extensive sexual assault that he had lived through. And what I hope now, as somebody who's sort of been on both sides of this equation, is that we set up a system. People always say to me, they're like, well, okay, what did you need? I said, really what we need is for it not to happen to begin with. And if it does happen, for the person to have the level of mental health support that they need. Prison, I am a huge fan of accountability, and actually hearing my perpetrator take accountability, I really think was the paradigm shift for me. All restorative justice starts with accountability. I took part in a national survey of survivors of various types of violent crime, and the results that came back were very pro second chance for people who do what many of our second look recipients did, which is take responsibility, right themselves, and come back in an accountable way. Survivors are not a monolith by any stretch of the imagination, but I always like to note that the communities most impacted by violent crime are also the ones most incarcerated. And as I work with survivors on bills to benefit them across the country in states where it is just appalling, I hear case after case after case of people who were raped, kidnapped, killed this person and are serving a life sentence. Kate Mogilescu, who I literally fangirl over, is going to appear later today, who handles the Domestic Violence Survivor Justice Act petitions in New York State. When we first talked, one of the things that has been so frustrating, it took them 10 years in New York to pass DVSJA, 10 years just to help domestic violence survivors, and they carved out first degree. And that meant that a huge swath of people who suffered abuse that makes what I went through look like a day out at the park for ice cream are going to stay behind bars. There's a massive clemency petition, but literally I say to her, like, I'm working on the second look bill in New York State, and I literally say, like, I think about them. every single time because we're so addicted to incarceration. We're so convinced that this is the way forward, that we leave them in prison so that we can say we're tough on crime and we don't go for the worst of the worst. And I will share this because I have a number of friends here, so I'll be supported. I'm just out of a domestic violence situation within the last 3 years. And you really have to be like getting yourself handled to understand the murderous rage that comes up when you think that this is not going to end. And I always say to people, like, I'm out here and free, but in my mind, I'm much closer to those people who are incarcerated than I am to the people who are out here and free. There should be a distinction between the people who are truly dangerous to our society and the people that we're mad at. And we really have to take a look at ourselves. If the only people that you care about today are survivors themselves, we need to be able to go back and review sentences.
Thank you. I would like to hear, Becky, I think I saw your hand up. I would like to hear from Becky and James and Nazgul, if you also want to talk about this question of how should our second look laws be informed by the needs of survivors. And I just also want to note to Dr. Kinshirf, I see you joined us, so we will turn to you momentarily. Thank you for joining us. So Becky, I'll turn it over to you.
Thank you. And first, let me just thank you, Alex, for sharing that story. It's so powerful, and I'm continually amazed by you. So I just wanted to add, my work as a prosecutor for 2 years included victim contact, and it was extremely difficult for me. And I think for other prosecutors too, I'm sure. But I think I made probably 100 phone calls during that 2-year period, and I would characterize it as a complete range of responses to very, very angry and upset to I even got, is he still incarcerated? I didn't know that, to I'm okay with him being released now. It's been enough time. I even had someone that said, I'm rooting for him, let him know that. And then a lot of in-betweens, like I'm not sure how I feel. And then I would say 40% of the people I tried to contact didn't want to be involved at all. It's been 30 years, it's been 40 years, they're good. So in terms of creating restorative justice, we offered restorative justice practices. We partnered with Restorative Response Baltimore, and we did send several families and the persons who were convicted of the crime to them. They did an amazing job. These are true angels who do this work. And what I would like to see is more prosecutor offices offering that type of counseling and healing. I don't think they do. I do get a little nervous when thinking about adding that to a law, just because I don't want it to be done haphazardly, or a governor's office now creating a victim restorative justice and they're not bringing in the right people. So I do get a little nervous about that, although I absolutely believe it should be something that is always offered to victims, no matter what the crime is or how long it's been, because it can be so healing.
Thank you. Well, so James, so Becky just talked about, reservations about like this issue being sort of explicitly included in laws, but I am curious, in DC, in the IRAA, like, is it informed at all by victim input?
Sure. And I'll preface all this by saying that I think the kind of engagement with victims and the family members of victims in these cases is at least one part of kind of DC's law that I think could stand a lot of improvement. So our statute has a list of 10 enumerated factors that the court must consider in determining whether or not a sentence reduction is appropriate. One of those is the position of the victim or the victim's family members if the victims are deceased. And so that it is something that the court is required to consider. However, a couple of data points here. I think, and this, you know, I think is a function of the kind of uniformly very serious nature of the cases that DC handles because of the eligibility requirements. We're almost exclusively talking about murders and serious sexual assaults. And the age of a lot of our cases, which is that they're not, most of them are not 40 years old or 30 years old. Some are 30, but you know, a lot of these cases are 16, 17 years old, 20 years old. They're not, people are not so far removed from them, but more often than not, in our cases, the victims or victims' family members do oppose release and they do oppose resentencing. I think it is absolutely true that victims are not a monolith and that we do see a kind of wide range of responses from victims. And a lot of times it's kind of more nuanced than can really be captured in kind of I oppose or don't oppose. It's I have questions, I have kind of mixed feelings, and overwhelmingly the sentiment that's expressed is that I don't feel like this process is kind of prioritizing or kind of vindicating my kind of needs as a participant here. But so that being said, I think more often than not, you have the victims when they're contacted and when they participate in the process, they are opposed to release, generally speaking. But even when that's the case, our judges have ordinarily, assuming someone was otherwise brought a meritorious case, or have granted release over victim opposition. And I think the reasons for that, I think, are one, just kind of a general expectation that in serious cases like this, that victims are not generally going to be supportive of release. We do see it occasionally. Again, a lot of people have feelings that are actually kind of hard to box in, but judges understand that the law is for people who committed very serious offenses, and that oftentimes in those cases, the people harmed by those offenses are not going to be, you know, understandably not going to be kind of eager for release. And so it's rarely treated as dispositive. But the other thing that I think has guided a lot of our judges is this kind of distinction between the function of sentencing and the criminal system, as there's kind of some ambiguity about what role and kind of interest in the process victims and their families actually have. They're not parties to the case. The community, society is kind of the interests that are being vindicated here in sentencing, and certainly the victims are kind of an important part of that consideration. But I think a lot of judges have taken the view that even where victims oppose, there's a kind of broader kind of interest of the community in kind of having just and proportionate sentencing, and that can outweigh. But so I think, and to Alex's point, that this is really important, is that one of the biggest obstacles I think our victims and victims' family members have to release in this whole process is this sense that the people who harmed them or harmed their family have not taken accountability and have not kind of had that, have not expressed kind of contrition or remorse. And it is often the case, or it is rarely the case, that is because they haven't wanted to, or that they don't have those feelings. We have a kind of adversarial criminal system, a system of prosecution and a system of sentencing that disincentivizes in various ways people from taking responsibility for the harms they've caused. Especially when you're talking about really lengthy sentences like this, you're talking about life sentences. People are told, and I think more or less correctly from the time they're sentenced, that you can't go on record taking responsibility for this because you're going to foreclose any any chance at freedom you might have. You're going to foreclose any post-conviction opportunities you have if you reach out to the victim's family and say, I'm so sorry for what I did. And so that is one kind of strong incentive against the taking of responsibility and kind of accountability. Another big part is that for even those guys who are not disinclined to do it, they're not given an opportunity to do it. You know, they may not have a way of contacting the victims' families or family members of the victim themselves, and quite reasonably, I think a lot of them think that they don't want to hear from them. You know, they know that they committed a kind of, you know, irretrievable or kind of irreversible harm against these people, and they think that those people never want to hear from them again, and so they don't reach out, or they don't know how to reach out. And so I think the biggest improvement we could see, and I think it's difficult to kind of incorporate this into our kind of existing kind of criminal legal system and sentencing system and everything else, but is the kind of creation of opportunities for you know, restorative justice process, a process of kind of meaningful engagement and accountability, and that gives victims and their family members a chance to be heard and feel like their participation is kind of valued, and also gives the people who have committed harms a chance to engage with that in a kind of sincere way, in a meaningful way, without fear of kind of all the kind of consequences that could come to their, you know, well, if I take responsibility, does that mean I'm never going to get out? I mean, that's a tough decision for someone to make. And so I you know, absent being able to like fundamentally change the character of our criminal justice system, which is a tall order, I think if there can be kind of created avenues for restorative justice that are, you know, kind of parallel to or kind of peripheral to the resentencing process, so that when folks know that the person who you know, harmed their loved one or harmed them is coming up for resentencing or petitioning for resentencing, there is a really kind of thoughtful and skillful attempt at engagement to improve outcomes for victims specifically, but that I think in turn will improve outcomes for everybody. But we haven't seen that here. It's tough to do. The prosecutors, I think, kind of have a monopoly generally on finding victims and their family members, because they have access to kind of the various tools that the criminal legal system has and that the public safety infrastructure has to find people. And so, you know, they're able to find them when we aren't. They have a credibility with victims and family members that we don't. And in our jurisdiction, at least, the U.S. Attorney's Office is not interested in engaging with victims in that way. Their mode of engagement is generally one to suss out whether or not someone opposes release or not. If they oppose release, then it's a way to kind of figure out how do we kind of amplify or make their opposition most effective. If they don't oppose release, it's kind of like, okay, you can participate and say whatever you want. We don't, you know, we don't want to kind of.
I just want to
engage
highlight
further.
that point real quick, James, because there's just this incredible thing that happens that if you want to go to war with this person, you are pumped up, you're protected, and if you literally are like begging for this not to happen, you are told that this is better for you. I was literally told, you don't know what's going on right now. This is going to make you feel better. You're going to thank me for the rest of your life. I did not and do not feel that way.
So this feels a little bit clunky, but I want to bring Dr. Kinshirf in because he has joined us, and I'm so...
From vacation in California.
From vacation in California. Dr. Kinshirf, I am Jessica Brown. I'm the director of the Center for Justice Reform at Vermont Law and Graduate School. Thank you very much for joining us. I will just briefly say that Dr. Kinshirf is a PhD and a JD, and currently the executive director of, let me get it right, the Center for law, brain, and behavior, affiliated with Harvard Medical School. So he's very fancy. And so, Dr. Kinscherf, we have been talking about second look legislation, extreme sentences, and consideration of reviewing them. And what we've learned is that many of these laws, the second look laws, focus on people who committed their offenses when they were under 18 or maybe under 25, and and have served 20 years or more, right? And so the people we're talking about being released are 50, 60 years old. And so I'm sure you could talk about this normally for a full 90 minutes, but what can you tell us about the brain science that's, what happens to the brain between 17 years old when someone maybe commits a violent crime and when they're 60 years old and we're considering them for release?
Thank you for the opportunity to do this. We're going to be making a little bit of a shift from the sort of deeply personal ways in which these kinds of crimes impact people and communities to what this may look like from 30,000 feet if you're trying to look at this through the lens of policy and long-term outcomes in aggregate cases that total in the thousands, if not hundreds of thousands, across time and across our country. I am going to do the most perilous thing that I'm going to try all day today, and that is to share my screen. I have some team experience. I'm mostly a Zoomer, not to be confused with a boomer. I apparently am one of those as well, but we'll give this a try. Okay.
For the record, I love this man with my whole heart.
All right, so can you see what I'm trying to show you? I've hit share. Somebody who is a team person, tell me what I do now. Share content. Presenter
Hold on,
mode.
tech person coming up.
Hi, can you hear me?
Wait, yes, I can. Do I hit the screen, surface display?
Yep, so you hit share, right?
I did.
And you can either hit window, as you see the window option.
Yes, window option.
Click on that to give you options for different windows to share, and you can click on the one that you want to share.
How's that? Can you see that? Yes?
Yes, we can see
We
it.
can see it.
Excellent. All right. So thank you again for the opportunity to present to you. We're going to do sort of a quick overview, and I will apologize in advance if you have any scientists or neuroscientists in the amongst the participants. I apologize in advance. And if you have lawyers, which I'm sure you do, I will also apologize in advance. This is the curse of trying to do a quick survey, is that you sometimes lose nuance, but I'm hoping we can have a little time to talk. And let me see if I can get this to start. All right. So we'll start from the perspective of normative adolescence and emerging adult development. And I offer this with the proviso that there's a lot of reason to believe that many of the young people who come into contact with the juvenile and criminal justice system are actually atypical, especially if they have encountered that system 2 times, 3 times, 4 times, 5 times. And but we'll start off just talking about what we have learned in recent years. And this used to be revolutionary. Thankfully, it is becoming more and more common for people to understand this and its implications. So for those of you who are already familiar with this, my apologies. So adolescence and emerging young adulthood is a period of transition and risk. And I find this kind of data instructive in understanding how their neurodevelopment within its own social context, because each brain is developing within the very specific environment in which it finds itself developing, But this sort of gives us an aggregate picture of adolescents and emerging young adults. They have more car crashes, even if you control for the practice effect, and they get better at it, thankfully. They're more likely to have unintended pregnancies. And look at the peak and the quick drop-off of unintended pregnancies, about 18, 19, 20. They drown more often. And again, the peak, a slower drop-off, but the peak in the exact same place. They attempt suicide more often, engage in more non-suicidal self-inflicted injury. This is a very stark graph. And you'll see with the onset of puberty, non-fatal self-inflicted injuries sharply skyrocket and then slowly drop over the course of the lifetime. They're more likely to experiment with substances and develop patterns of substance misuse. And again, I find this one particularly interesting, and we can talk about why we may have such a high peak of substance misuse in the late teens and very early 20s, but look at that sharp drop-off. And by parallel, the meeting the criteria of the DSM at the time that the study was done, addictive patterns of substance use, but again, dropping off, peaking at the late teens, dropping off in through the early 20s. And one of the reasons why we're here today, if not the reason, compared to adults, adolescents and young adults commit more crimes. We've known this for a long time. We've also known, this is why I deliberately picked the 1988 graph here. It has stayed the same, and we've basically known about this age crime curve since at least the late 1920s into the 1930s, peaking in mid to late adolescence and then sharply dropping off starting at about 1920, 21. And that continues to date. It takes a while to compile national statistics on crime, but you can see the same phenomenon, whether it is property crime or violent crime. And counterintuitively, at least to me, violent crime drops off more rapidly than do nonviolent property crimes. We've seen arrest rates go down over recent years. During our period of conversation, we might want to talk about what that might reflect. But our peak in arrests occurred in the early to mid 1990s and has dropped off since that time. Although if you ask most Americans, or if you were to not have this information, you were to listen to many politicians, you would think that the United States continues to be in an ever rising grip of crime by adolescents and young adults. We've had a bit of a spike in some places, not nationally, but in some places, particularly gun crime, but not an overall general rise in crime around the country. We've actually had a much sharper rise in suicides than gun-related homicides or other crimes against persons around the country. This simply reflects violent crime rate by age grouping, and seeing that across the years, the rates have been dropping quite consistently, both in violent crime and property crime. And so one of the things we learned is that the adolescent and young adult brain is a work in progress. It's really quite remarkable. The only other parallel time for brain development where there's this extensive reworking of both structure and function of brain systems is in the intrauterine and early child period up to about 36 months or so. But this is really an extraordinary development, and we can see it in patterns of behavior and decision making. I will spare you my obsessive fascination with dense PowerPoint slides with all kinds of citations and numbers. And instead, I'll just give you a quick view at this with sort of aggregate data in graphic form. Impulsivity shoots up with the onset of puberty, earliest puberty, and consistently declines with age. This takes us up to the early 30s here, and we're going to want to keep a look at both the peaks and valleys and what people are looking like at about 26 to 30. Sensation seeking declines with age. The next two slides together are my favorite. Risk preference is highest in mid-adolescence. Novelty, stimulation seeking, risk taking, peaking at about 16, 17, and beginning to sharply drop off in late adolescence and early young adulthood. But at the time that their risk preference is highest, their risk perception is lowest. Risk perception is defined as the ability to actually assess risk and then apply it to your own personal situation. So if you just look at public health surveys, for example, and you ask adolescents and early young adults, will you be healthier or less healthy if you smoke cigarettes? They look at you as though that's a silly question, because it is, and they will tell you flippantly that, you know, of course you're going to be less healthy if you're smoking cigarettes. Are you more likely to have an unintended pregnancy or contract a sexually transmitted disease if you practice safe sex or not? You get the same response. They know the right answer. You're less likely to have a pregnancy, an unintended pregnancy, or a sexually transmitted disease if you practice safe sex. You can ask them the same question about driving without a seatbelt, skateboarding without a helmet, and yet in all of the major physical risk kinds of public health questions, they are very good at getting the right answer, but they are the demographic least likely to act on that information in their own situation. Future orientation will increase with age. The ability to defer gratification, to build plans towards longer-term goals and the like. They're more willing to delay gratification, beginning to peak again at 18 to 21, and up we go. If we have time for discussion, we can look at the drop at 26 to 30. We think that's an artifact of what they're delaying gratification to get. This is one of my personal favorites also. With age, they literally spend more time thinking before acting, and spending more time thinking about harder problems with life-altering consequences and easier problems that really are not particularly challenging and have almost no long-term life consequences. I remember a young man describing to me his decision-making process when he agreed. He was about 16. He agreed to join a 22-year-old cousin in a robbery of a convenience store. He didn't even know that his cousin was armed with a gun. And I was talking to him about, well, how did you make the decision? He said, well, my cousin called me on Thursday and asked me if I wanted to go with him to rob a convenience store on Saturday. And I said, okay, so what happened? He said, I thought about it when I was on my way home. Now, on his way home from school was about 10 minutes. And by the time he had received that phone call just as school was ending, and 10 minutes later, he walked into the house. He had made two decisions that were going to shape his behavior that afternoon and over the next couple of days. One was he had decided he was actually going to play a little PlayStation before he made his Hot Pocket in the microwave. And the second one was that he was going to lie to his parents about where he was going to be on Friday night and instead go with his cousin. I saw him in the context of his indictment on felony murder. With age, individuals become more resistant to peer influence. And neuroscience has helped us understand that there are actually parts of the reward system of the brain that are activated if they are either being witnessed by peers when they're engaging in a risk-taking behavior. Those same reward systems will light up even if they correct, even if incorrect, if they think, even if incorrectly, that they're being watched by their peers in some sort of remote way. Significant activation in these centers of the brain. And by the time you're 25 to 30, those centers of the brain no longer activate when doing something in the presence of peers, especially a risk-taking behavior. So this information created some challenges, and we saw those challenges reflected in some Supreme Court cases. One of the things that was puzzling is that with this data and with other behavioral science looking at these issues specifically, most adolescents by about age 16 are about as good as most adults in capacities associated with being competent to stand trial. Most adolescents are about as good as most adults in other decisional competencies like medical informed consent. One of my favorite Scalia dissents involved a Supreme Court case on the issue of whether or not adolescent girls should be required to notify their parents before getting an abortion. And Scalia was, in his dissent on that case, he was outraged. And basically he said, now, wait a minute. You've shown up in Roper, which is the Supreme Court case in which execution was taken off the table for crimes committed under the age of 18. And in Graham versus Florida, you've told us, which was the case in which life without possibility of parole was taken off the table for non-homicide cases. And then in Miller, which was no mandatory life without possibility of parole, you've told us that adolescents should get essentially a sentencing discount because they are impulsive, they're reckless, they can't think two thoughts through to their logical conclusion. And so you want us to give them a pass for serious crimes, including murder, but you want us to think that they are contemplative and calm and can make other life-changing decisions without adult assistance, or at least without a particular adult's assistance. And I don't get how you square these things. And to be fair, Scalia was right. He was pointing out what the state of the science was and wanted to know how we could reconcile that. And the truth of the matter is that at the time, that science didn't yet exist. Similarly, we had to understand how they could be as competent as most adults in a number of decisional contexts and yet see this spike in reckless behaviors, 16, and then beginning to diminish in late adolescence, and especially as you into 21, 22, 23 years old. But what we didn't know at the time, or have the research to verify our intuition, and having raised two adolescents through into post-launch adulthood, I think any of us who have raised kids have known that it's quite remarkable how the same kid who can be on this is actually a colleague of mine's son, be a scholarship student in physics at Stanford, could think it was a good idea, resulting in his arrest with 32 other young people by the Fort Lauderdale police. Could be a straight A physics student at Stanford and still think it was a good idea at 2 o'clock in the afternoon, because they had discovered that tequila is not just for breakfast anymore, to disrobe themselves and run as a naked pack through a very tony marina in Fort Lauderdale, and think that that was a wise thing to do in the moment. But what we have since been able to show, both in naturalistic studies and lab studies, the difference between cold and hot cognition. So those contexts in which by mid-adolescence and shortly after, 16, 17, 18, they are about as capable as most adults in making decisions, that's under cold cognition circumstances. The environment is relatively calm. They have the time and the tools to make well thought out decisions. They have time to consider inputs, especially from people, often adults, whom they trust and think will give them guidance and will help them identify and act upon options. And they're capable of more logical, reasoned thinking and long-term planning. Under hot cognition, for example, that is not the case for many adolescents. Under hot cognition contexts, their thinking process is more like 13 and 14-year-olds than it is like 26 and 27-year-olds. And so they remain vulnerable to decision-making deterioration, quality of decision-making under stress, especially if it's at a time of high emotional arousal with a sense of immediacy. It's very emotionally influenced thinking, more susceptible to the influence of others and the like. Now, I want to show you this because up to this point, we've been talking about the characteristics of brains, but I earlier referenced that each brain is developing its systems, brain systems, on basically a use it or lose it strategy in the specific context in which that brain is developing through this very rapid and vulnerable course of neurodevelopment. And it turns out that if you look at the research on social determinants, it's basically the same set of social determinants that are the risk determinants for physical health, the risk determinants for behavioral health problems, including the onset of disabling conditions involving anxiety, depression, post-traumatic functioning, and substance misuse. These are also the same social determinants that put you in elevated risk pools for crime and also specifically for violent crime. And if you look at these, almost all of these are outside of the individual decision-making or control of an individual adolescent. They're outside of the control, usually, of most adults who find themselves in environments where they are subject to many of the social determinants or negative social determinants of health, behavioral health, crime, and violence. And these social determinants are not only powerfully influential in the likelihood that you will be a perpetrator of a crime, they are also powerfully influential as to whether or not you will be in the social context where you're most likely to be the victim of a crime. Now, like all things that are based on aggregate data, there's a huge range of individual outcome, but I think that these are worth thinking about since science is based usually on group data. In fact, the larger the sample, the more confident we are in the outcome. But courts are being asked to make individual determinations in individual cases. And under our system of justice, unlike some other systems of justice where words like humanity and dignity and even hope actually have a legal valence and legal significance in their legal discourse, that's not what we hear about that is mostly persuasive in our juvenile and criminal justice systems. Somewhat more in the juvenile system, but still not as compared to our peer developed nations. So our overview of the landscape regarding second look, especially for young people, I've referenced these cases before. Roper, 2005, at the time of the Roper decision, which basically braided two constitutional lines of jurisprudence. Children are different and death are different. The United States was one of 3 countries that still allowed for the execution under judicial order of persons for crimes committed under the age of 18. Graham, non-murder, no life without possibility of parole. Miller, they fell short of eliminating life without possibility of parole for juveniles as a class, as they did in Roper. And the compromise position was no mandatory life without possibility of parole. And that line of jurisprudence, although it was extended nationally in the Montgomery v. Louisiana case, in the view of many of us, has now sort of been wrecked on the shoals of Jones v. Mississippi, in which the current Supreme Court has essentially backed off from seriously considering science and developmental neuroscience in furthering the Eighth Amendment jurisprudence as applied to juveniles. This has meant that the knife fight has now devolved to the states on the issue of life without possibility of parole, but has also devolved to the states, since I don't think there is a pathway under federal constitutional jurisprudence to things like second look legislation. By 2020, 3 states had accounted for 2/3 of the juvenile life without possibility of parole. Quite counterintuitively, at least to me. It was not the usual suspects of highly punitive systems that we usually think of. Pennsylvania and Michigan had the largest number of persons who, at the time of Miller, were juvenile life without possibility of parole cases. Louisiana is usually one of the usual suspects. And it's worth considering that as of now, about 1 in 7 inmates are life without possibility of parole, or who have essentially de facto stacked sentences, life possibility of parole. And most of these people are convicted of crimes committed in late adolescence or early young adulthood. And by that, I mean between the ages of 18 and 23 or 24. The Sentencing Project, in their recent 2023 monograph on this, reminds us that 2 in 5 of the life without possibility of parole inmates were under 25 when they committed their index offense. So this is not an inconsiderable number of people, and that's just the life without possibility of parole. There are even more people who essentially have de facto life sentences, giving the probation and, the parole practices in the states in which they are incarcerated and the lengths of their sentences. Now, recidivism rates are a little dicey. The data often varies by duration and whether it is counted as recidivism upon arrest or only recidivism upon conviction. But as a nation, we lag far behind our peer developed nations in recidivism rates. And roughly, there's some wiggle room in these numbers, but roughly, I think people would agree that we're in the neighborhood of the 40 to 45% rearrest rates at 1 year and astonishingly close to 2/3 at 3 years. There's some variations across states, but that's pretty much what it looks like. And we have, I'm sure I'm preaching to the choir when I point out that we have been through an era of mass incarceration at this point. So recidivism rates, the highest recidivism rates are found in Alaska, the lowest in South Carolina. Vermont has a 43% recidivism rate on the data that I could find, which ranks it as 32 out of 40 states. 10 states have declined to submit their recidivism data to the federal government and to researchers. Our companion states in New England are roughly the same, with Massachusetts ranked 16th with about a 1/3 recidivism rate, and Connecticut the highest, ranked 38th with a 49% recidivism rate. Now I want to turn our attention to those who have been convicted of homicides, because that's often when you hear about these debates, it's the homicide cases that raise opposition or misgivings. And so I just wanted to show you a little data specifically on persons who committed homicides and were subsequently released. This is a study that I participated in that the prime investigator was Frank DiCataldo, a little dated, 2017, but we did this study because the previous studies that on recidivism for persons who committed crimes as juveniles or as emerging adults was all over the map. And some studies found surprisingly low, some studies found surprisingly high. A lot of it, I think, had to do with the jurisdictions in which they found themselves. We found almost no data on age of release in any of these earlier studies, and we may want to pay attention to that because it may be part of what we'd be thinking about in a second look model. In our sample, which was a very small one, average age at conviction was 16, but the average age at release was 29. Of those 22, 15 at an average of over 7 years post-release in the community. 15 out of the 22 had no arrests, no convictions. We had one person who had come back on a nonviolent crime conviction. I believe it was a drug possession charge. We had 4 who had committed a violent crime without a weapon. These were mostly simple assaults, and 2 had committed a violent crime with a weapon. There were no homicides, no sexual offenses. And as near as we could tell, although it was a little hard to gather some of this data, none that involved the infliction of serious injury upon the victim, even in the violent crimes. But the interesting feature of this, of course, was how long they had been out, since we know that the most, 2 features. One is their age at release, 29. And this study was done after they've been in the community for more than 7 years, because we know that the highest recidivism occurs in the first 24 months and goes down statistically for each year that they remain free and offense-free. Now, Zatelli and Defer Kapoor, and they're updating this research now. This was a study that they did in 2020, and now they've got a couple more years of post-release information. They have a relatively large sample. They were young people, almost all men of color from the Philadelphia area, who their total sample was 269. They followed 174 who had been released following resentencing post-Miller, and their recidivism index was arrest, not conviction. For 49%, and this also tracks the data that we had in Massachusetts when we looked, for 49% of the people who were serving these very long de facto life or life without possibility of parole sentences in Pennsylvania, for just about half of them, this was the first time they'd ever been arraigned on anything, which makes us have to consider carefully about whether or not there may be different developmental trajectories we want to take into account when looking at the likelihood of new offenses, rehabilitation, institutional adjustments, and the like. Only 3% had two prior adjudications before the courts. 38% of them were there on felony murder. In Pennsylvania, that's their definition or their equivalent of a second-degree murder. The average one-year recidivism rate for all recidivism is about 44%, as we mentioned before. The average age of release in the Pennsylvania study was 51 years, with quite a range between 35 and 66 years. Hold on to your hats. 3.5% recidivism rate on any crime, any arrest, right? And for those who had been, and that included the ones who would have had capped second-degree sentences, and the average life without possibility of parole, 1.4% had come back on any arrest. They did some interesting things that I urge my colleagues and myself to do more routinely. They also costed this out and determined that releasing the sample of 174 in the first 10 years alone would save the state of Connecticut, if they chose to accrue these savings, $9.5 million only in correctional costs. Now I show you this because I found it of interest. These were the risk factors most correlated with being in that cohort sample. And I showed you before the social determinants of crime and violent crime. And I have highlighted in yellow the ones that, at least arguably, the adolescent or young adult had some control over in the decisions that they personally made. I doubt, for example, that they, growing up, had much control over whether or not they were going to witness caregiver domestic violence or family criminality, the neighborhood they lived in, whether or not their parent had a mental illness, all these sorts of things. So it's interesting to bring a social determinants lens to the notion of individual accountability for conduct if many, if not the overwhelming number of the risk factors for being involved in these more serious crimes are things that are largely beyond the individual control of the person who is before the court as they grow up. This is not to diminish the notion of accountability at all. Adolescents and young adults can make wretched and sometimes dangerous and sometimes even lethal decisions, but it does make us wonder when we become focused on the details of the index offense, the crime that brought them before the court, if we may be missing a lot in trying to understand them in terms of their developmental trajectory.
Dr. Kincher?
Yeah.
This is Attorney Brown, Professor Brown, oh my gosh. I mean, technically I am still an attorney, but I want to interject because I really want to be able to open it up to questions and discussion.
I think I've got 3 slides.
Okay, go for it.
And this is the take home. This is the bacon. I've teed you up with the hors d'oeuvres. Here's what the science tells us overall. Social determinants are huge variables. Most, even violent delinquents, will self-desist as they enter adulthood. The heinousness of a crime does not predict recidivism or lower rehabilitation potential, which is fascinating because when you look at resentencing and parole hearings, the proceedings in many states start off with a recounting of the crime and the government often arguing about the heinousness of the crime as though that was actually relevant to the question of who the individual is now. And that would only be a red herring. There are a lot of things that are said in court that are irrelevant, but here, beginning a parole board hearing with a recounting of the crime creates cognitive anchoring, which biases the decisional processes of the people hearing the case, the parole board. And we have some good science for that. We know that lengthy sentences do not deter crime amongst this group. And with maturation, violent young offenders are amongst the least volatile prison inmates. And the desistance trajectory, and here's sort of one of the take-home points, it substantially lowers recidivism risk by about age 30 and continues to drop with age until by the time you get to 40 or 50, the recidivism rates are extremely low, and by 50, less than about 5%. And that's all crime, not serious crime. So what we'd want to do is think about a look back. We'd want to think about a way in which you can make case-by-case determinations starting in the late 20s to early 30s. If you really have a person with a more troubling record, you might want to extend it out to see what they look like at 35 or 40. But by the time you're past 45, you're in the sweet spot. We also want to try and avoid as much as possible the collateral consequences that come with these kinds of convictions. And I'll just leave this up while we talk because you can read it faster than I can say it.
Thank
All right.
you so much. This is so.
Let's have a round of Stump the Chump.
Here's what I want to say to folks in the room. Let's do some questions. We have some buffer because we're just going to go down the hall and grab our lunches in Yates and bring them back here. So let's take some time to do some questions, then we'll go get our lunch and come back and keep going. Okay, so folks in the room, if you have a question, raise your hand and someone will come to you with a microphone. And Cora, let me know if there are any questions online.
And I know that was very taxing for the brain, so thanks.
And your questions can be for Dr. Kinshirf or any of the panelists about anything that we've heard this morning. And if you're in the room asking a question, if you just introduce yourself, please.
Good morning, Sam Dworkin. I'm a attorney, private defense attorney in Barry doing juvenile and criminal defense work. So my question is there a difference in the recidivism rates as people age for serious violent crimes of a sexual nature and ones that are not of a sexual nature?
Did you hear the question?
Yes,
So
is it
the
directed to
question
me?
was, certainly, we could certainly start with you, and if anyone else has some information, feel free to chime in. But the question was whether there is a difference in recidivism rates in sex offenses versus non-sex offense crimes. Is that right? Yes, among the serious crimes that we're talking about that might receive extreme sentences.
So we have some pretty good data on the developmental trajectories of persons who are adjudicated under the age of 18 for sexual offenses, the whole range of sexual offenses. If you look at them as a group, the recidivism rate amongst juvenile sex offenders is actually surprisingly low. If committed as juveniles, it appears to catch the same curve of self-desistance as they age, with some important exceptions. For example, sexually motivated homicide or sadistic rape, but that mostly trends down amongst adolescents and young adults. The best data we have now, looking at multiple studies over about 15 or 20 years now, is that the sexual recidivism rate, they may go steal your car, but the sexual recidivism rate of adolescents is somewhere between 3 and 7%. In fact, for some adolescent sex offenders, the rate of reoffense risk is so low that we don't want to send them to specialized sex offender treatment because they're probably not going to do it anyway. And we don't want them being socialized as an adolescent into the identity of a sex offender who will always be a sex offender. Some of the models of sex offender intervention with juveniles are no longer that crude, but some of them do risk creating a sexual offender identity, just like for low risk offenders, incapacitating them by confinement with higher risk offenders tends to raise their risk rather than lower their risk as an inadvertent consequence of congregating them together in juvenile facilities.
Also, the Sentencing Project does have a CSN, a crime of a sexual nature brief that Dr. Kristen Budd is currently working on, who's sort of one of the foremost experts in the country. She has taught me a very great deal as a survivor of a sex offense about recidivism rates. And although I'm not going to speak officially to that because it's her publication, recidivism as it is seen publicly for sex offenses and the way that sex offenses are talked about is incredibly inaccurate pretty much across the board.
Other questions in the room or online? Oh, Cora, why don't you give us one from online?
Yes, so this is from Timothy Leaders Dumont, the legislative and assistant appellate attorney on behalf of the Executive Committee of State's Attorney in Vermont. Which offenses should be eligible to receive a second look? Likewise, which types of sentences should be eligible and what length of sentence should be eligible?
So what types of offenses should be eligible for second look, what length of sentence, and what was the last part?
It's what type and how long should people serve, basically, is the question. Who should be eligible for a second look?
Well, I can tell you what the science would say. The science would say that since for this age group, the nature of the underlying offense is not really helpful information in terms of recidivism risk or for potential for rehabilitation, that you could apply a second look to the whole range of offenses. And that's one of the reasons why I showed you the recidivism data from persons who had committed youthful homicides. Which ones to include is at least as much a social and moral decision as it is a scientific decision. But what I can say is there's no basis in science to exclude a particular sentence. And it would suggest that in the majority of cases, if somebody has been incarcerated for 10 to 15 years, for example, and you may want to make it longer, as I was mentioning in my talk, for people who've had more turbulent early institutional adjustment histories, you're going to have a pretty good bet. And we have very good risk tools now, and a second look is a second look. It isn't get out of jail free. If you have continued to be a violent offender or otherwise problematic during your institutional adjustment, the odds that you would prevail at a parole hearing or a resentencing hearing are actually pretty small in my experience. On the other hand, we have lots of young people who come in at 18, 19, 20 into adult offenses. They have a first turbulent few years. And then quite frankly, what happens in prison is what happens outside of prison, which is their brains turn on and they start figuring out how the world in which they are living really works. And if they continue to believe that there could come a time when they could be released, basically what the European Court of Human Rights referred to as the right to hope, then you see them become actually amongst the most easily manageable, most amenable to programming, and least violent cohort in prison settings. In the prison systems that I go to, people work really hard to get onto the lifer units because they are the least violent crowd.
I would just add to that, great response that in terms of what legal experts recommend on this issue, the American Bar Association recommends a second look after 10 years of imprisonment for youth convictions after 15 years for adult crimes. And they note that there was a lot of debate about this, and some of the experts that were consulted in drafting that decision recommended beginning resentencing after 5 to 10 years. The American Bar Association recommends resentencing begin after maximum of 10 years. And we as an organization at the Sentencing Project recommend that resentencing begin within 10 years of incarceration. And I also just want to add one quick international point. Since you all are so far north, it's important to recognize that other countries like Canada, for example, have eliminated life without parole sentences. Many European countries have done the same. And in terms of the duration of time that people serve in prison, one country that we can compare ourselves to is Germany, for example. For even the most serious crimes, people do not serve past 15 years. And so, I think that really looking internationally sometimes is very helpful to help us kind of recalibrate and get a sense of how exceptional and extreme our sentencing is in the United States.
If I could just briefly add to that, in many of our peer developed nations, two prominent ones being the Dutch and the Germans, you don't even, they have a juvenile system that goes up to 18, young offender system that goes up to age 25. You cannot be incarcerated with persons over the age of 25 if you have committed your crime under the age of 25, because they've realized that if you take younger offenders who have a high likelihood of rehabilitation and self-desistance, and you put them into prisons with much older people, you actually increase your recidivism rates. Ironically enough, they stole that model from federal model legislation that was proposed in the United States but never passed in 1947.
Wow. We're going to take one more question. Dr. Kincherf, could you put up your last slide? Because I think I saw that it was going to be a Frederick Douglass quote. So, and we'll take one more question from our founding director, Bobby Sand.
If I can figure out how to do it. Let me see if I can figure out how to do it. How do I put my slides back up?
Oh, they're still up.
Oh, they're still up? So you just need...
Yeah.
Did that do it?
Go to the last... Not yet.
Hold on. I see what needs to be done.
There we go. Thank you. Okay.
Thank you all for a really interesting presentation. I'm Bobby Sand. I'm a professor here at Vermont Law and Graduate School. But most relevant to my question, I was a prosecutor for 22 years, 15 as the elected state's attorney or DA for this county, and have literally met with hundreds of harmed parties, crime victims, and explained to them the implications of the sentence that has been imposed. I am 100% in support of second look prospectively. I'm 100% in support of second look retroactively, where it has the support of the harmed party or the harmed party wants nothing to do with it one way or the other. Help me understand why we should have second look retroactively over the objection of the harmed party.
Yeah, I would be happy to take a stab at that. I think that the parallel to the death penalty is important to consider. When the death penalty was abolished in many European countries, the majority of people in those countries were opposed. They still supported the death penalty, and over time, people's opinions changed. As they moved away from that extreme punishment, people became more supportive of abolishing capital punishment. In the United States, we've had a similar trend in states that have done away with capital punishment. And similarly, in those states where capital punishment does not exist, there are situations where victims want the death penalty. They want the person who took away their loved one to be executed. But we as a society say, we do not offer that kind of retribution. We draw the line and we say that that is a kind of punishment that we think goes too far as a society. And so similarly, we can do the same thing with extreme sentences. And ideally, as we discussed earlier, that would come alongside restorative justice policies and investments so that victims can come to terms with the harm that they've experienced, and so that they have as much support as possible to become either, supportive or at least be neutral about someone being resentenced and released who caused so much harm to them. So there's certainly a lot of work that needs to be done. But for me, I think that's a way to think about it.
Could I also just add to that? This system sucks in a lot of people. I think we need to think about trauma and victimization a whole lot more broadly, to Dr. Kinshrift's point, because what is often very clear to me, talking even to DV survivors, is that there's a lot of failures that happen before we get to that moment. And we're not addressing this over here. We're just offering this over here, which is the extreme sentence. But actually, if that doesn't deter, if that doesn't stop future victimization, and we haven't addressed why this happened up front, I think the challenge of Second Look is that it requires the system to sort of take accountability and start to put in all these factors that Dr. Kinshrift was like, okay, well, if we allow people to be subject to abuse and they can't get out, if we have people who are suffering from ACEs, poverty, homelessness, you name it, untreated mental health, as with my perpetrator, victimization that was not addressed that then turned me into a victim, then we need to go back and take a look more holistically. And I totally understand. I'm literally making a speech at the NVR DC, which is our survivor group in DC, on the 9th. And they chose me because one of the things that they say is that we've let down entire sections of our community, particularly Black and brown communities, because if you look at any sort of poverty structure data, if you look at trauma, ACEs, you name it, that's where you're going to see this massive population. So we put people into a situation to commit crimes and then come back and criminalize them, and then don't want to deal with our culpability in that. So, I remember having the discussion with my own family about corporal punishment being completely acceptable in a Black Southern household, that was part of our culture, and that talking about being offended against is something that you don't do. You take it on the chin, you keep on trucking, and then something happens and we act shocked. Now, I could hate him for the rest of my life, and for 15 years I did. And I think I had every right to be angry. But if for me, and of course I don't speak for all survivors, but for me, I would much rather see us all put our energy to there being no more survivors, and not going back and looking at our own mistakes is to say that we are perfect. We know this system isn't perfect, because hell, if it was perfect, I wouldn't be passing domestic violence survivor justice acts anywhere in the country. In DC, we've considered all offense types. It has worked out.
I want to just give Becky or James an opportunity to answer that last question before we close out. No one, if no one wants to add anything, whoops, okay. Then I'm going to thank, oh my gosh, these amazing panelists, James, Nazgul, Becky, Dr. Kinshrift, and Alex. This has been so informative and incredible. And really, I think, gave us so much foundational information to think about moving forward. So thank you so much for your participation today. We really, really appreciate it. For those of you in the room, you're going to head through those double doors, through the next set of double doors, follow the students. They'll lead you to Yates Common Room. Get your lunch. Please bring it back here. Stretch your legs, use the facilities, then come on back so we can keep going. All right? Thank you.
Thank you.
Thank you, Dr. Kinshrift.
Thank you for the opportunity.
Good afternoon, everybody. May I say, from this vantage point, you all look great. I'm Bobby Sand, a professor here at Vermont Law and Graduate School and the founder of the Center for Justice Reform. So when I went to law school here back in the 1800s, the professors would all emphasize that judges are the most powerful actors in the criminal legal system because they impose sentences. And then in the wake of innumerable instances of excessive use of force by law enforcement, people started saying, well, police, law enforcement officers are the most powerful people in the criminal legal system. And then people started realizing that maybe it actually was prosecutors, that they were the most powerful actors because they made the charging decisions and they decided whether to negotiate resolutions, plea bargains. And in many respects, that's the predominant view, but I want to offer a slightly different perspective, and that is that the most powerful actors in the criminal legal system are legislators. The systems that we have now were either created by legislators or inherited by them. And we will not fundamentally change criminal legal systems in this country until legislators recognize that the system is a system that they own and that they have the greatest power to change. And we're really lucky now to have a presenter who is one of those legislators who is deeply committed to changing the system. So Tanya Vyhovsky is a state senator representing Chittenden County in Vermont. She has championed second look legislation and championed reform of our monetary bail laws in her non-legislative time. She works as a social worker primarily with justice-involved youth. We are incredibly lucky to have Senator Vyhovsky.
Hello, and thank you so much for having me today. It is such an honor to be here with all of you to talk a little bit about sentencing in Vermont. As Bobby said, I'm Senator Tanya Vyhovsky, and I serve the Chittenden Central Senate District, comprised of Burlington, Winooski, Essex, and a little sliver of Colchester, so our most populated towns in Vermont. And I serve on the Judiciary Committee. I'm a proud lead sponsor of S-155, a bill that would end life without parole as a sentencing option, provide compassionate release for those who are terminally ill, and would enact second look policy, allowing for sentences to be adjusted based on a series of criteria and a petition by the person sentenced for a review of their sentence. This policy would not guarantee release, but establishes the right for someone who has been incarcerated to have their sentence reevaluated after a period of time for potential adjustment to that sentence. Now, why would I sponsor a bill like this? I am a person who believes at my core in the resiliency and transformative capacity of all people. I believe that nobody is irredeemable, no matter what they have done. Nobody should be cast aside based on an instant of their lives. I believe that with hope, support, and community, human beings are capable of incredible growth, transformation, and healing. As a person who believes in the incredible transformative power that people have, the very idea of locking someone up and throwing away the key flies in the face of my values and my beliefs. What hope can you have when you have been told and shown that the world around you believes there is no hope for you? What is the point then of even trying? This policy not only squashes the fires of hope, but also fails to acknowledge the harm done by our society and to the very people that are being handed these life without parole sentences. As expected, sentencing, like our entire criminal legal system, are racially and economically biased and perpetrate deeply entrenched systems of marginalization and oppression. Now, I am not naive enough to think that every person will transform themselves and will heal their trauma or work towards restoring the harm that they have done to others and their communities. Some may stay stuck in patterns of harm and violence, but I also know that many will not if they are given the tools, support, and hope that they need to do this hard work. I know in my heart, and the statistics back me up, that what we are doing is not working. Our sentencing practices and overall correction system is doing more harm. It is putting out the very fire of hope that people need to heal that harm and to be members of our society. This legislation is a first step towards a different possibility in our correction system, one that is grounded in hope and resiliency. We as a society like to say that our criminal justice system is meant to rehabilitate people. And I could spend all day talking about whether this is actually the true purpose of our system, but that's not why we're here today. What I will say is that it is often the stated purpose of this system, and I know that we are failing. The system is not working. It is not making our communities safer, and we know this. But let's for a moment accept that this could be the goal of this system and work towards that dream and work towards building a system that is in fact restorative and rehabilitative. If we were working towards that as the ultimate goal, then life without parole and long sentences with no possibility of review must be ended. These practices put up front that we do not truly believe that this is possible, that some people are beyond redemption, beyond the capacity for growth and transformation. It says that for those people, this is not what our system is for. In the vein of moving forward, these practices must be eliminated. We must take this step at putting our policy in line with the idea that all people are worthy of a chance to be redeemed, to heal, to repair harm, and that people are worthy of hope for the future. If what we're doing were working and truly making our communities safer, we would be the safest country with the least violence in the history of the world. We do not have to dig beyond yesterday's news to know that this is not the case. We spend an astronomical amount of money and human capital incarcerating by far the most people in the world. Yet there are many places with outcomes that are much better than ours, with much lower rates of violence, lower rates of violent death, and we should look to these countries. Let us, for example, look to Norway, one of the safest countries in the world. A country that does not allow sentences for longer than 21 years for any individual crime and has a maximum of 30 years for crimes like genocide and war crimes. In Norway, there are a small number of locked prison units, fewer than we have in the state of Vermont, despite their population being nearly 10 times the size of Vermont's population. The total prison beds in Norway are just under 3,600, with many of these units being unlocked or open prisons. If a country the size of Norway does not rely on life sentences, does not allow for anyone to be sentenced for longer than 21 years, and does not even lock some of their prisons, how is it that they are so much safer? How is it that they see so much less violence? And how is it that their recidivism rates are so much lower than ours? People often point to the robust social service programs available in countries like Norway. And I would agree wholeheartedly that there is an incredible need to invest in our community supports and services that would ensure all members of our communities have their basic needs met, because this is truly public safety. We know that extreme sentences are not good policy. Evidence shows that people age out of criminal behavior, so continuing to incarcerate people once they are elderly ignores that they are no longer violent. We know that these long sentences are not effective deterrents because most offenders don't expect to get caught or are acting without reason. And it's incredibly expensive to provide the health care and supports and services, which comes from 100% state money versus our community supervisions and services that would make people Medicaid eligible and thus only comprise 10% state dollars. And we know that survivor views are also important, and offenders need a chance to take accountability and to help heal the damage they have done. It costs us nearly $100,000 every year to incarcerate one person in the state of Vermont. Over a lifetime, this is millions of dollars spent crushing hope. Hope for the individual and hope for our larger community. What could these millions be better spent on if we truly wanted public safety? The very social services that we lack and the reasons we are told that a model like Norway's would never work here. The cost of lengthy terms of incarceration and life sentences are not just monetary, though. The cost, and that cost is clearly enormous, but there is a very real human cost. And we all bear the burden of both the economic and human cost every day. I believe that we can do better. No, I know that we can do better. Many will give us a list of reasons why we cannot make these changes, why we cannot move the system forward toward truly being grounded in healing and restoration. We will hear about the victims, and their story is important. We will also hear about community safety, but we already know that the system as it is now does not have good outcomes for either one of these things. So I have to stop and ask myself, can we actually afford not to make these changes? We have skyrocketing rates of homelessness, overdose deaths, gun violence, and deaths of despair, and this is directly linked to a population that has lost its hope. The system is not working. It is not keeping people safe. It is not preventing crime. It is not meeting the needs of the victims of crime. And it is not healing or rehabilitating our communities. We absolutely must do better. I introduced this bill because I was asked to, but more importantly because it aligns with my values. It aligns with my faith in the transformative capacity of each and every person. As a social worker, I've seen the incredible capacity for people to heal, to transform, to forgive, and to do better when they are given what they need to thrive. When people believe in them and provide them with the tools to grow and heal. Opening the prison doors is a building block of this healing, opening those doors to hope by elimination of life without parole and ensuring a second look policy as a bare minimum for us to say that we believe in you. We believe in your capacity to heal, we believe in your capacity to transform, and we believe in your capacity for restoration. This will allow us to build a system of hope and healing rather than trauma and despair. I'm certainly happy to talk about the specifics of the bill, but I know that that's going on a lot today, so I won't. I want to thank you all again for having me and for being here, and I know that I'm going to need your help and support in the State House next year. We're going to hear a lot of reasons why we cannot do this, but what I'm here to say is we have to. Thank you.
We are so lucky to have you up in Montpelier, our state capital. And may I just say, on second look, you all look fabulous still. So our next presenter may be the only person in this country to hold a PhD in restorative justice, which she earned in New Zealand. Dr. Lindsay Pointer is an author. She is a professor here at VLGS. She is the principal investigator / director of the National Center on Restorative Justice, a partnership between VLGS, the University of Vermont, the University of San Diego, and our federal partners, the Bureau of Justice Assistance. Lindsay brings a wealth of restorative justice knowledge, skill, national and international connections to VLGS, and she has an abiding love of public speaking. It is my pleasure to present Dr. Lindsay Pointer.
Thank you, Bobby. And yes, thankfully I'm not going to be speaking very long because it's not in my strengths area. So what we're really going to be using this next bit of time for is a facilitated dialogue. So I first want to mention we have a few members of our National Center on Restorative Justice team here today. So we have Alana Ojibwe, if you can wave hello, Alana. Demointe Wesley, and Avery Arrington, and of course, Bobby Sand, who you have already met. And then we have Brashani Reese and Sarah Robinson, who are also going to be facilitating circles for us today. So we'll be moving into a chance for dialogue in just a moment and a chance to really apply a restorative lens together and start talking about some of the great material that we've been learning about this morning. But just wanted to take a moment to kind of set us up for that discussion, for that dialogue. So as Bobby mentioned, I'm part of this National Center on Restorative Justice team that is a partnership with team members all around the country. And our mission is really to improve criminal justice policy and practice in the United States through restorative justice education, training, and research. So we have a really wide range of projects that all are focused on that central mission. And restorative justice has already come up a number of times this morning, which has been really exciting to hear. And for those of you, though, who might be newer to restorative justice, I just want to mention real quick, before I talk more about what it is, that if you find yourself really excited and maybe hungry to learn more about restorative justice after today, the month of November, we have declared Restorative Justice Month. This is the first time we're celebrating the whole month. Des Moines put together this really lovely flyer that you can find at the table out front that has some of the offerings that we have over the course of the month. There's lots of great webinars, videos, podcasts, all sorts of opportunities to learn more about restorative justice. So you can use the QR code or follow the link. And we hope you'll check out the rest of our website, too, that has a lot of great resources for learning about restorative justice. So make sure you check that out. Happy RJ Month, everyone. It's going to be great. So want to talk just for a moment about restorative justice. So Brian, if you can share our question slide. Sorry to put you on the spot. So restorative justice, it is a collection of practices, certainly, but perhaps more importantly, it's a paradigm shift, right? When we think about that question, what is justice? When we're pursuing justice, what do we mean by that question? Restorative justice, we often talk about it as looking at this question through a different lens. So if you look at it through that lens, all of a sudden everything changes, right? One of the ways that I think it's easiest to get your head around that paradigm shift is to look at the questions that we're asking in restorative justice. So if you look at most of the kind of conventional criminal justice responses that we're familiar with, that kind of more punitive paradigm, you see the questions on the left being asked. So what rule or law was broken, who did it, and how should they be punished? You know, how severe should that punishment be? How long should it last? It's kind of variations on those questions. And so what we're doing in restorative justice responses is really shifting the questions that we're asking to instead ask the questions on the right. So understanding what happened, and not just in a specific incident, but also everything that led up to that moment. So what are some of the, some of those public health determinants that we were talking about earlier? What are the contributing factors that we need to understand in order to understand what happened? Who was harmed? What was the impact of what happened? What do they need now? So what are their needs, both materially, socially? What are the needs of both the harmed party or victim and also the responsible party or the person who committed the crime, as well as their surrounding communities of support? So really looking wide, looking at those ripple effects and the needs of all of the people involved. Whose obligation is it to meet those needs? Oftentimes that means the person who caused the harm, the responsible person, has obligations, but a lot of times it means society has obligations, right? A lot of those structural components that lead to these incidents. And so considering that obligation and responsibility more broadly. And then, what is the appropriate response? So thinking creatively about how we can then meet those needs of individuals. So what we're going to do in just a moment, so I'm gonna turn it over to Brashani for a little bit more framing, and then after that, I'll come back on the microphone for a second to give you instructions on how to find your circle dialogue groups. But what we'll be using the time to do together is to use some of these restorative questions as a lens to think about this second look topic of the day. So taking a moment to really digest and work through what we've been talking about already this morning and intentionally applying this restorative lens. So I'm going to welcome Brashani Reese up to give a little more context, and then we'll dive into dialogue.
Thank you so much. Thank you. I'm really excited to be here with you this afternoon. I'm really just going to so I have 2 slides, so I'll ask Brian to just go ahead and and move that forward. Dr. Kinshirf was my mentor. I had many lectures with him. I love him, could listen to him for hours. I'll keep this very brief, 3 to 5 minutes tops. So when we talk about restorative justice, the questions that were just posed are theoretical questions, but we're about to go into discussion groups where we're actually trying to practically apply these questions. So wanted to give a little bit more context. 2 requirements before restorative justice can even begin. The first is the survivor's willingness and consent to participate in this process. The second, and actually Alex named this earlier, the second is accountability. So the person who committed the harm has to be in a place where they're willing to take accountability. Without that core value, there really is no RJ practice to be had. So there are 4 goals, very generally speaking, about the restorative justice process. The first, assessing the harm that has been done on all levels. So this speaks to the reality that when violence occurs, and I am going to focus on violence. I'm a huge proponent that RJ does best in violent crimes, in cases of violent crimes. Violence tears a fabric in the tapestry of the community. And so when we're assessing that tapestry, we're looking at the visceral response that we all rightfully have to a violent act that has occurred. The second goal is to assess and develop a plan to talk about repair. I just want to add that in the case of violence, there's really not a way to bring somebody back. And so a full repair / restoration, right, of what has been done is not really possible. So we say in RJ, we can't make it right, but we can try to make it better. It's also important to say that in assessing that, all of that harm and what's needed for repair, that this is an opportunity for the survivor to have agency and really talk about the harm that was done to them and have a voice in the process. Someone mentioned earlier about that the crime is against the state. It's not against the person. The prosecutor is not the attorney of the survivor, and they will say that to you when they're representing, the state's case in court. The third goal is to support the journey of the person who experienced the harm. So when a plan has been developed about what is needed, we then as a society say we're going to step up and help you implement that plan, and we're implementing that plan for potentially years, maybe even decades after the consequences of what happened. The last and the fourth goal is supporting the journey of the person who perpetrated the harm, that journey may be towards change and accountability. So it's very focused. Their journey, from our perspective, needs to be a little more focused. Brian, if you could give me my second slide. So why is it important to talk about practical implications and not just theory? Well, with all theoretical models, there's a huge difference between what we're talking about theoretically and our practice. Before the first thing that I mentioned was that the survivor needs to consent and be willing to be a part of this process. So timing of the offering of restorative justice is key. I don't know that anybody really wants to be asked the day after they lost their son to homicide if they would like to sit down with the person who did it. Some people may, but I think a lot of people might not be up for that right away. I also mentioned that the core value is accountability. So I will caution and reiterate something that Nazgul said from TSP. Beware any mandated restorative justice. And yes, I say that with an ominous voice. I come from Massachusetts, where they have built it into legislative processes. You run the risk of making restorative justice hollow when you put it as a carrot in front of somebody to get their freedom. So now I'll give one example of when we go through the goals, how it can quickly get complicated, because the goals sound easy in theory. Assessing the harm. I said that the response to violence is visceral. I would just like to point out that not for all communities. Because if you come from a community where your experience of violence has not been validated and your pain is not substantiated, then actually the reaction could be numbness, and that this is just the reality of how the world works. I talked about creating a plan for repair. I want to very gently say it's survivor-centered, not survivor-dominated. So survivors are very much a part of the process, but if we just allow for simple power over, then all we're doing is replicating potential needs for vengeance. Like power over is not really a great way to be in human relationship. Now, supporting the survivor's journey, well, the survivor's needs are probably going to change over time. And controversially, maybe I'll say this, some survivors want something different than what their family wants for them. So hearing the needs of that actual survivor can be really difficult. And then lastly, supporting the journey of the person who perpetrated the harm. In our society, this is where we run into the controversy. This is where people move away from the data and move very much into what is morally and culturally accepted. So I want to remind us as we move into this discussion that the goal of restorative justice is to mend the tapestry as best we can, the hole that has been ripped in the fabric of our community as a result of violence, and also prevent future violence. RJ is survivor-centered. It's an active process of justice, but because it requires people, it requires us to take case by case, be creative, flexible, patient. So as we go into our small groups, I would just ask that we think about how do we survive harm, how do we support survivors? Like really, how do we support them, right? And then how do we hold accountable and support the people who are willing to try to make some level of amends for the harm that they have done? Thank you.
Thank you so much, Prashani. Okay, so I have your instructions for how to find your circle groups. For those of us who are in the room, there are 3 circles set up upstairs. So if you just go up the staircase, there's 3 circles up there. There's one in the back of the room, right back here, and there will be another one right over here in this kind of wing of the room. There's about 6 or 7 people per circle based on the number of us who are in the room. And so what I'll invite you to do in just a second is to get up, take an opportunity for movement after lunch, and find your way to one of those circles. If you come to a circle and it's already full, just carry on to the next circle, and there will be a facilitator there to meet you. For those of you who are joining by the live stream and watching online, Cora is putting a link in the chat that gives a link to a Zoom meeting. And so what we'll ask you to do if you'd like to join the dialogue space is to click on that link, join the meeting. Alana will be there to meet you virtually and to guide you through that circle dialogue, and then you'll come back to the live stream link after the end of the circle. So the facilitator will guide you through some questions. It's an opportunity for reflection, and then we'll come back together here as one large group for the rest of the afternoon. Sounds good. Great. All right. Thanks.
Hi, everyone. We are going to get started with our next speaker, who is going to be introduced by our very own Professor Shannon Heery. Yay.
Hi. Okay. Thank you, everybody, for your participation in that last restorative circle. I thought that was great, so thank you to the team as well. But I am here. I'm Professor Shannon Heery. I am here to introduce the wonderful Professor Steve Zeidman, who is joining us virtually, and we really appreciate his time. So Steve Zeidman is a professor and the director of the Criminal Defense Clinic at the City University of New York, or CUNY. He's a graduate of Duke University School of Law, and he is a former supervisor at the Legal Aid Society, which is a public defender's office in New York City. Prior to joining the CUNY faculty in 2002, he was the executive director of the Fund for Modern Courts, which is a nonpartisan statewide court reform organization. Between the clinic, his prior positions in clinical work at NYU, and his role as at the Legal Aid Society, Professor Zeidman has served as an educator for hundreds of public defenders across the state and the country, while simultaneously shaping New York policy as a lead advocate for change in the criminal system. I could go on and on about his background and accolades, but for purposes of this conference and our timing, I will focus on his incredible efforts in the realm of clemency petitions and resentencing that we're all here to learn more about. Recognizing a deep need for those most harmed by our laws who are currently serving lengthy prison sentences in New York, Professor Zeidman created the Second Look Project Beyond Guilt in the CUNY Defender Clinic. Students working in this project support incarcerated individuals in their clemency and parole petitions. To date, they have worked with more than 100 people, securing freedom for 40, with close to 2,500 outstanding requests for help from those languishing in New York State prisons. Many of the people who have been released through their hard work are among the leaders of the reform movement in New York. Fueled by the lack of existing process for review of these lengthy sentences, Professor Zeidman has been a lead advocate for adoption of second look sentencing bills in New York State. He has also written extensively on the need for second look generally across the nation. And finally, as a member of the ABA Criminal Justice Section Council, Professor Zeidman drafted the ABA's second look resolution, which, as you may have heard this morning, provides their recommendation for adoption of second look legislation nationwide. With all of that, let me welcome our incredible keynote speaker, Professor Steve Zeidman. Thank you, Steve.
Thank you, Shannon, for that introduction, for inviting me to participate. I have to say, I wish I was with you all. Scheduling being what it is, couldn't make it. I have deep connections to Vermont. I should probably start there. My daughter's a Middlebury grad. My two nieces are University of Vermont grads. But perhaps most relevantly to this moment, the work we do at CUNY Law School in New York in our Defenders Clinic, we have a very close working relationship with the extraordinary folks at Bennington College, their prison education initiative. They provide college classes to people at Great Meadow Correctional Facility in New York, a maximum prison in New York, about 20 minutes away from Bennington. And several of their students are, in fact, our clients who we are trying to extricate from death by incarceration sentences. So I'm in Vermont all the time. I wish I was with you. I've been engaged in what I call post-conviction work with my students at CUNY Law School since about 2015. And we work exclusively with people who are serving life and long-term sentences. People really most of the people we work with are facing the reality of perishing in prison, given the length of the sentences they are serving. And so I think of second looks in that kind of context, people dying in prison. And I also think we have to situate the discussion within the concept of mass incarceration, because it has struck me over the last 10 years how interesting it is, how fortunate it is that it seems now that everybody is familiar with the crisis of mass incarceration, left and right, liberal, conservative, Democrat, Republican. I am sure the numbers came up this morning. I think most of you are familiar with the numbers. 2 million incarcerated in this country, 5% of the world's population, more than 20% of the world's incarcerated. But I also think it's important, again, to focus on when did this happen? Because the through line through all of this is the question of race. is the question that in our prisons, the people serving these impossibly long sentences are disproportionately and overwhelmingly people of color. So the spike that we saw in the prison population, certainly we saw it in New York State, blue progressive New York State. We saw it so plain and clear, growing right out of the movement, the civil rights movement, when suddenly we saw the Get Tough on Crime, the war on drugs, and other carceral policies, in particular legislation, that began to pop up that has led to these massive sentences. So if mass incarceration is a crisis, the next step, and this is where I think we're stuck, is what to do about it. Because if you look across the country, the overwhelming majority of remedies are prospective in nature. There are bills to get rid of mandatory minimums, to get rid of sentencing enhancements like 3 strikes and you're out, to rethink the availability of alternatives to incarceration. That's wonderful. But if we really are focused on mass incarceration, we have to look at the present living embodiment of the crisis, the people who are presently behind bars. And as I am sure again came out this morning, people talk about mass incarceration, and I think there's a quick sort of movement where people get to the notion of policing, that it's because of hyper-aggressive policing, particularly in certain zip codes, certain neighborhoods, communities of color. And that, of course, is part of it. But from my perspective, the larger problem we have is the massive sentences, the sentences that are routinely handed out. And I say this, we've had these conversations in New York for the past several years. And if you were with me in court in New York City, I'm talking about, next week, and we went through the 5 boroughs, we would see people still, young people, getting sentences like 50 to life, 75 to life. There's this urge to punish that is something we have to address. And I think second looks is one way, even though it's after the damage has been done. So again, I know we're in Vermont, but let me just situate a little bit in New York. You've heard people talking about 20-year maximum sentences in most other Western industrialized nations. In New York, we have over 6,000 people serving 20-year minimums. We have close to 7,000 people serving sentences with a maximum of life. So it's within that context that I began to get involved in the need for second looks. So let me give you sort of a composite scenario. This is something we confront in our second look project several times a week. So it's a composite, but I urge you to try and imagine, put a face on this, all right? A woman comes to our office and she says, when my son was sentenced to 50 years to life when he was 25 years old. He was running with the wrong crowd. He was doing dangerous things. He was carrying a gun. He was involved in the drug trade. There was a robbery that went terribly wrong. He fired 5 shots. 2 people were killed. He was sentenced to 50 to life. It's now 25 years later. He's 50 years old. He's served 25 years. He's a remarkably different person. He acknowledges responsibility. He's done everything he can to atone and repair. What can you do to try and get him released? That's the question we face. It's the aftermath of mass incarceration. And when I've raised this scenario to people in the media, to legislators, to students, at conferences like this, people usually suggest that there are 4 possible ways to remedy the situation, if one is inclined to try and remedy the situation. One is parole. Is a person eligible for parole or compassionate release, what in New York we call medical parole? What about clemency, the power of the executive? What about exoneration, wrongful conviction, going to conviction review units in the DA's office if the person is claiming they were innocent? And finally, most relevant to our discussion this afternoon, what about resentencing? What about a motion in front of a judge? So let me kind of go through the first 3 pretty quick and then get to where we are with resentencing motions, second look bills. What about parole? And the question in New York is whether someone doing 50 to life who's been in 25 years, is there any sort of off-ramp by virtue of parole? And this is one of the things that I urge my students. I know this sounds like I'm joking, and I'm really not. I say, here's your public service announcement at every Thanksgiving. because it still happens to me at every Thanksgiving. Someone will say 50 to life. So what do? They get out in like 20 years? When you get 25 to life, what do? 12? And the truth is, there are some states where that is not necessarily so off base. New York is not one of them. This is not hyperbole. This is my view. We get blood money from the federal government. It's the Truth in Sentencing Act. And what that means is when you do 50 to life in New York, you know when you first become eligible for parole? At 50 years, period. So this 25-year-old is destined to perish in prison. Because in New York State, the chances of someone surviving 50 years and making it to 75 are slim and none. So parole, and we can talk about parole at another conference and the need to overhaul the parole system across the country, but that offers no hope to this woman's son who's doing 50 to life. What about clemency as a second look option? The power vested in the state's governor. And I want to mention something that comes up frequently as well when those of us who are doing clemency work, when we make statements something like governors don't use the vast power that they have, inevitably someone from that particular state governor's office says you're wrong. You say in New York there's been hardly any clemency. In fact, there have been 600. And what it took me a long time to understand, I was just ignorant of what clemency meant when I started this work. So we're talking about clemency as an umbrella term for pardons or sentence commutations. And yes, there have been hundreds and hundreds of pardons in New York over the last 20 years. Those expunged convictions, they're wonderful things, but what they all have in common in New York, every single one of them, is they were given to people who were out of prison. Most of them had been out of prison for decades, and I think you all know the typical scenario. Someone is facing deportation because of a marijuana conviction from 25 years ago. They seek a pardon. Those are far less controversial. When we're talking about the other part of clemency, a sentence commutation, those are rarely granted. Why? Because they're for people in prison. And in New York State, the people seeking sentence commutations have two things in common. They're serving very long sentences, and they were convicted of very serious crimes. And because of that, it's been very tough to get governors to move. And by the way, someone might know this. I checked this out in Vermont. I'm not familiar with the Vermont process. I believe the governor has the power to issue pardons and commutations in much the same way as other governors. I looked from 2005 to 2021. I didn't see a single pardon or a commutation. I could be wrong on that. But this is just, to me, it's part of the second look conversation. Because to give you an example, and again, if Vermont is all like New York, in New York, the power to grant clemency is unfettered. The governor has absolute total power in the state constitution. I'll just read the one snippet of it. The governor shall have the power to grant commutations for all offenses upon such conditions and with such restrictions as he or she may think proper, period. There are 1,100 pending clemency applications on our current governor's desk. She could sign all 1,100 tomorrow, and there's nothing that could be done short of someone using it politically. There's no appeal process. There's no commission. So when we began this work in 2015, it was the first 4 years of then Governor Andrew Cuomo's administration. Anyone want to guess how many sentence commutations he had issued in those first 4 years? You could probably guess. None. And we were told clemency as a way of second look, yeah, it exists, but governors, they're elected, they're afraid to do it. And we began to push. And as we began to get some people clemency, the people who got clemency and came home began to lead the charge. So by the time Cuomo left in office, and it is, I know it's a drop in the bucket, but it's a hell of a lot better than zero. 41 people had their sentences commuted. All of them were convicted of very serious crime. The majority were convicted of homicide. Our current governor has already commuted the sentences of 10 people and has made a commitment to do this on an ongoing basis. So what role can we all play regarding clemency? To me, it's just calling for it's calling governors out for not using the vast power that they have. You know, for the law students, the law professors in the room, I asked a colleague of mine who's a constitutional law scholar, I said, you know, how many powers does a governor have in the state constitution that are so vast and unfettered that they don't have to go to the legislature? They don't have to go to any commission. They can just do something tomorrow, like release somebody from prison. And the answer I keep getting back is, I'm not aware of any such power. They were even unfamiliar with the clemency power. So the question for us is, if it's there, why isn't it being used? And obviously the only answer we hear is it's politically dangerous. So that brings me to the other pathway to freedom for people serving death by incarceration sentences: resentencing, second look bills, turning to the legislature, the impact that the legislature can have. Here's the problem in most states. And I have 2 research assistants trying to give me a 50-state sort of a head count on this, looking at every state's current resentencing laws. And it turns out the majority are very similar to New York. So again, here's this person who's 50 years old who's done 50 to life. And we think as lawyers, what about going back to court? It's been 25 years. There might not be the same judge on the bench, but we're going to go into that same jurisdiction and say, we use the word equity all the time. The equitable powers of the court, more vernacular, to do the right thing. I'm going to file a motion in court and say, Judge, would you resentence this person? They've done so well. They're so changed. They might even have the support of the victim's family. When we first started doing this work, again, showing how naive and ignorant I was about this, that's what I said to the students. We're going to draft some motions. We know how motions work. You can almost make up a motion, right? It's a matter of what's the harm, what's the remedy, call it whatever you want. We're just going to call it a motion for resentencing. Except we had to go look at the statute, obviously. And New York's resentencing statute, which is all too typical, which is what Vermont is and Senator Vyhovsky is trying to address. This is the typical resentencing statute in America. This is straight from New York. Motion for resentencing by the defendant. At any time after entry of judgment, the court in which the judgment was entered may, upon motion of the defendant, set aside the sentence upon the ground that it was unauthorized, illegally imposed, or invalid as a matter of law. So we read that and say, is that a potential avenue for relief for this woman's son? And the short answer is no. The sentence, while draconian, was legal. The 320 people serving life without parole in New York State, those are legal sentences. The thousands more serving de facto life without parole, those sentences were legal. So when we filed our first motion, we were very swiftly rejected because the court said, what is the legal basis for this motion? And we said, well, what about the interest of justice? Because in New York, again, like most states, when you're arrested, when you're initially arrested for any charge, you can move to dismiss in the interest of justice. After you're sentenced, and let's say you get life without parole, our first level appellate court can reduce your sentence in the interest of justice. But 10, 20, 30, 40 years later, if you want to move for resentencing, there is no provision like the interest of justice. So as more and more attention is being given to this void, the fact that there's no way to recognize and value redemption and change and transformation, we now have 2 bills pending in New York State. And they share a lot in common, but I want to mention one fundamental difference that I am glad to see, if I'm reading the Vermont bill correctly. The Vermont bill does much better than the New York bills. And by the way, the New York bills have a fair amount of support. Our problem in New York actually is that we have these 2 competing bills. And the members in the legislature are saying to the advocates, which one am I supposed to support? We're sort of at a standstill. One of them is a version of what is sweeping across the country called prosecutor-initiated resentencing, PIR. It essentially adds the words "in the interest of justice" to our resentencing statute, but it's preceded by saying the prosecutor may, in the interest of justice, move to have the defendant resentenced. The second bill, which is promoted by community groups and advocates, allows anybody to seek resentencing. In fact, it goes further, and there was a great debate when we were all drafting this. It doesn't just allow somebody to move for resentencing after 10 years, because we were concerned that some people who've been incarcerated for a while might, just for a variety of reasons, not have the capacity, the wherewithal, the help they needed. So what's built into this law is it's a mandatory second look after 10 years. And I also want to say, and I think this is, again, the same thing, which I think is wonderful about the Vermont bill. A lot of the bills across the country, they have some version of what, bill drafters refer to as the C word, carve-outs. It will exclude certain crimes. Ironically, the most serious crimes like homicide, which are the people serving the longest sentences who most definitely and most earnestly and urgently need resentencing. Or they will be limited to things like if you are over 55, or if you are under 20, or you were under 25 when you were arrested and convicted. The New York bill that the advocates are championing has no such limitation. After 10 years, regardless of original crime of conviction or original sentence, you can move for resentencing. And I just want to mention a few other things about second looks. And this is really, I'm taking my cues from the pushback that I've received from not all victims advocates groups, not by a long stretch, but by some prosecutors' offices, by some legislators. What I've come to realize is that it's important to recognize that, at least in New York, a lot of these massive sentences, they may well have made some degree of sense when the sentence was imposed. I say that as someone who's not in favor of massive sentences, but I'll give you an example. One of the first people that we worked with successfully for clemency is a woman named Judy Clark. Judy was involved in a rather high-profile case back in 1981 in New York where 2 Brinks officers and a police officer were killed. It was an offshoot of the Weather Underground, part of the Black Liberation Army, a very high profile, a lot of raw emotion here in New York, 34 years later when we got involved. Judy was sentenced to 75 to life, the absolute maximum possible. And when I read the sentencing transcript, I was struck by what the judge said. The judge said, I've got letters here asking for leniency, but the harm you did, the things, your public statements, the way you've conducted yourself right up to this moment in this courtroom leads me to believe you will forever be a menace, that you will always be a threat, that you will always champion violence. And for that reason, I'm giving you the maximum. Now, I can take issue with what the judge was saying. When I say I understand it, I'm not saying I agree with it, but I understand where this particular judge was coming from. But you know what I've come to learn from doing second look work? Judges don't have crystal balls. They can't see into the future. It's ultimately hubris, because 34 years later, the way Judy's case came to me was that the superintendent of the prison was saying she should be out. She's done so many wonderful things in here. Formerly, presently incarcerated women were writing letters. Elected officials were saying she should be home. Faith-based community, the bar associations. And I say that because I keep reading these transcripts. Every time we get a letter from someone saying I got 50 to life, we get the sentencing transcript. And I have read so often judges saying, you are a menace, you will forever be a menace, you are a threat. And a lot of this goes back to the era of the so-called super predator, racist tropes like Wolfpack and Wilding. And this is especially true for people who were sentenced, obviously, when they were young. And we now know that even the Supreme Court accepts the notion of brain development through Roper, Graham, Miller, Montgomery. But here's the irony is not a strong enough word. Those Supreme Court cases, our conservative Supreme Court, say things like children shouldn't be sentenced to death or life without parole because they lack impulse control. Their brains are not yet developed. That portion of the brain where they can appreciate the consequences of their actions, develop empathy. And you read that language from the Supreme Court, and then you go back to sentencing transcripts. And I see things like judges saying, you don't appreciate the harm you caused. You lack any semblance of self-control. You show no remorse. And they use those things to maximize the sentence instead of to mitigate. And that's what a second look can rectify, can redress. And ultimately for me, there's a catchphrase, and I have to plead guilty. I know I stole this from someone at somewhere, but I just can't remember who to attribute it to. But someone said, the essence of second look is that a sentence once imposed does not remain just, necessary, and appropriate in perpetuity. And that's just so true. And we know the court system in criminal, they love finality. But what about whether something is just, necessary, and appropriate? Does that somehow go out the window? Or are we willing to take a second look? And I know, a lot of people who engage in this kind of advocacy, and I'm sure a lot of you have heard this phrase, they'll say something along the lines of, and I think it usually gets attributed to Brian Stevenson, a person shouldn't be judged by the worst thing they've done. Right? If I was in the room, I imagine I could get heads shaking if I asked how many of you have heard that. And every time I've said something like that, the pushback has been enormous. I had a judge say to me once, this was in a task force, you mean to tell me we shouldn't judge someone who killed somebody? That's ridiculous. And what it made me realize is we're missing two words from that statement. Far be it from me to try and correct Brian, but we are missing two words. A shouldn't be judged by the worst thing they have done in perpetuity. That's the problem. That's the problem. Of course, someone takes a life, there's going to be some degree, whether we call it judgment or something else, we're not going to look the other way. Something's going to happen. It's just, is it in perpetuity, or do we allow the capacity and recognize the capacity for change? So just a couple of more points I want to make. New York's new chief judge, Rowan Wilson, just created a justice task force with a subcommittee focused on second looks. And I had the opportunity to address that body recently. And one judge said to me, and to me, I think it's important to really surface where the resistance comes to second looks. One judge said to me, and I have this in quotes because I wrote it down at the time, I don't care how much they've changed. I don't care how much good they're doing on the inside. They took a life, and to me and to a lot of people, they forfeited the right to ever walk free. And he said to me, how would you feel if a loved one was murdered? How would you feel about the person convicted of that crime getting a second look after 10 years? And no one ever put it to me quite that stark. And we all know the challenges of when it's put on such a personal level, which is why those most impacted by long sentences are the best spokespeople for this. But in that moment, I wasn't going to lie. I said, I'm blessed. I've never experienced that kind of loss. I'm not going to sit here then. I'm not going to say this now that I feel like, I would be a forgiving. I don't know. I don't claim to know. Unknowable pain, unimaginable, immeasurable pain. But I do know this much, and this was about the best that I could say to him. I do know that in the work that we're doing, when we reach out to family members 20, 30 years after they lost a loved one, one thing has become very clear. We've offered nothing to those family members in these intervening decades in the form of any kind of support, any kind of therapy. The beautiful work, I'm sorry I wasn't there to be part of it, of restorative justice, has it taken root in that jurisdiction? What do we offer someone who is feeling the depths of pain from a loss of this nature? And I'm also reminded too of what I mentioned Judy Clark before. When she was granted clemency, the governor who had met her and who had reviewed a 600-page clemency application, he said to the press, because he knew there was going to be a lot of hostility when he did this, and there was, he said, we call it the Department of Corrections. Well, she's about as corrected as a person could be. And to me, that said just about everything. In the end, I have to hope, and this is what I said to that judge, I just have to hope that there's a place to recognize and value redemption. So a couple of more concluding thoughts along these same lines. I think if we want to talk about second looks, we have to confront a sensitive and hard question. And this is another time I'll plead guilty, because I felt like in the last 10 years of advocating for second looks, I've tried to avoid this question. That really is, how long must someone serve for a violent crime, including a homicide? Too often the conversation moves into all these people serving long sentences for drug crimes. And of course, that shouldn't happen. That's not who's populating most of our prisons for these long sentences. It's people convicted of violent crimes. How long must someone serve if they took somebody's life? And to me, to more directly convey the need for this conversation, for second look bills, is since we started this in New York, we're a tiny law school. But there's really no legal organization doing this on a large scale. We've received, at this point now, Shannon mentioned, I think 2,100, we're over 3,000 requests for help from people serving life and long-term sentences, people who will die without clemency or a second look because their sentences are so long. And I say that to thank the conveners of today's conference for putting this together. Because second look bills, this is not hyperbole, they save lives. They create the potential for saving lives. And I also think that the impact of granting clemency or a second look is immeasurable. The people that we have helped bring home, some of this is going to sound like a cliche, but I'll try and make it more than that. They are the credible messengers. They are the violence interrupters. They are leading advocacy movements. But you know what? You know what I think is more important than that? They're tending to their families. One person came home and was able to spend 6 months with his wife before she died. He was her caregiver when she was in the throes of ovarian cancer. He'd been incarcerated for almost 40 years. Others are tending to their sons and daughters. They're repairing families. And in the process of that, I do believe that they are increasing public safety, repairing families, and in the process, repairing communities. I also want to add the point of view of so many corrections officials and officers that I have spoken with. And it's interesting, I keep urging some of these folks to say this more publicly, and for reasons you can imagine, they're hesitant to do so. Every time one of our clients gets released, either through some sort of resentencing hook or clemency, and we go to the prison when they're coming out, correction officers come over, including a superintendent, to say, each time this happened, it reverberates across the prison. Men and women who gave up, who never left their cells, or who were disruptive influences, suddenly come out and want to re-engage with other people, with programs, in the hope that maybe, if they work harder on themselves, maybe they too might get this kind of relief. They tell us it makes a safer prison environment for every single person, people who are incarcerated and staff alike. And I say that to say, because right now in New York, without a meaningful second look bill, clemency is the only hope. A young person coming in with 50 to life, what incentive do they have to try and grow and improve, to take college classes, to rethink the confluence of factors that led them to this moment? One person wrote to me, this is something else I keep on my bulletin board. Some people who knew him who had gotten clemency said, you have to reach out to Kevin. He deserves clemency. He's been in almost 40 years. He's a mentor to us. And so we reached out to him. And he wrote back and he said to me that clemency is a hope. And hope is a luxury. And for me, clemency is a luxury I cannot afford. He didn't want to go through with the process because it's like winning the lottery. A second look bill would create real, concrete hope that is so desperately needed. And I'll conclude with this. On a really optimistic note, there is a growing awareness of the need for and the value of second looks. And I can say this in very concrete terms. Very recently, some of you might have seen, I think this is just November 1st, recent amendments to the United States Sentencing Commission, where they are all regarding sentence reductions. California, just yesterday, a new second look bill was signed by the governor. As Shannon mentioned, last summer, the ABA, judges, prosecutors, defense lawyers, academics, formerly incarcerated people, passed a resolution and report that urges all jurisdictions to pass second look legislation. And this to me was the key. No carve-outs. No limitation on original crime of conviction or original sentence, none whatsoever. And reading the draft second look bill in Vermont, it seems to me like a model. And I urge everyone in the room to do whatever they can to see that it is passed, and much respect and gratitude to everyone involved. Thank you.
Attorney Zineman, can you hear me? Hi.
I can.
I think I'm on screen now. My name's Jessica Brown. I'm the director of the Center for Justice Reform here at VLGS. Thank you so much. That was informative and really inspirational, and I really appreciate it. Do you have a few minutes if anyone in the room has questions?
Oh, sure, sure.
Thank you so much, Professor Zeidman. I'm Bobby Sander, professor here at Vermont Law and Graduate School. I'm curious if you know whether judges who are appointed as compared to judges who are elected, whether that makes any difference in their receptivity and use of second look.
Yeah, what a wonderful question. You're opening up a whole other can of worms. You just did it. Yeah, you know, the whether to elect or to appoint judges. I can tell you this, I'm not aware of any study about second looks, but I am aware in the capital, in the death penalty context, that it has been found that judges coming up for election are more inclined, and certainly if it has anything to do with appellate review, are less inclined to set aside a death penalty sentence when they're getting closer and closer to the election. And that has been demonstrated over and over. You know, my expectation would be that appointed judges, at least if they have enough years out, would be more inclined than elected judges, unless the election, you know, I guess that's why we have federal court judges for life. But, you know, long-winded way of saying I'm not familiar with any study, but it's a critical piece of this that has to be examined. I hope we get to that point where we are examining it. Because I heard you say at one point when you were introducing someone about how important legislation is to this every version of reform, and I couldn't agree with you more. So let's get the bill passed, and then, yeah, it would be a critical examination. Which judges are the least or most likely to grant resentencing?
Dr. Reverend Mark Hughes, Vermont Racial Justice Alliance here in the state of Vermont. I'm wondering, well, first of all, second look, I think it's the least we should be asking at this point. To me, it just seems like it's such a small ask. I know of a lot of the work that's been going on in these areas, but it seems like such a small ask. And I think we should treat it as such instead of, you know, taking it back over to Dick Sears and company and saying, please, 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 we should be looking at everybody and saying, look, guys, let's just get this done. Second thing is enfranchisement is really what I'd like to talk about in this context, because really what we're talking about also is folks who can't vote. Not here in the state of Vermont, obviously, or Maine, but there are 48 other states. So I'm wondering what the plan or what the thought is around that, or if there are any, because at the end of the day, it's really about our voice. You know, because a lot of folks are going to get out and are still not going to be able to vote.
Thank you for that question, Reverend. I want to start by saying I couldn't agree with you more about I think somehow we get boxed in this corner where we ask for second look as if we are begging for something, and it should be a small ask. One of the things I've tried to do, this is in the clemency context. Clemency is typically cast as an act of mercy. So forever and ever, governors typically would commute a sentence at the end of the year, and they'd make statements like consistent with the spirit of the holidays and the new year. And to me, I don't think I'm overstating. It's always been offensive to me. You know, someone once said it's like the nonsense that goes on, you know, pardoning a turkey on Thanksgiving. To me, it's not, we shouldn't be asking for mercy. It should be an obligation to rectify the crisis of mass incarceration. It should be an obligation, something that has to be done, as opposed to us begging for clemency or for a second look bill. What I think about the voting piece, I'm going to come at this in a different way. When I said before about the impact of people who get second looks who come home, there's a person we've worked with in New York named Bruce Bryan. Bruce, when he saw in New York that there was an effort to give people who were convicted of a felony the right to vote, what he recognized is that it wasn't in any way being discussed inside, it wasn't being actualized. Bruce, while at Sing Sing Correctional Facility in New York, reached out to a professor at the University, I think at University of Chicago, who had drafted this remarkable report about how to get more bills passed and how to make sure people inside and outside, people who are coming home, were aware of their right to register and to vote. Bruce took it upon himself. He convened a group of 10 other men inside Sing Sing and created an incredible program proposal, but also amendments to New York's law to give people not only the right to vote, but the way to make it happen easily and quick, you know, sort of like you apply for a license, but where he was focusing on the formerly incarcerated. I say that just to say two things. One, it's the talent and skill that is languishing inside, but also to highlight, I couldn't agree with you more, that it's, you know, ultimately, how do we want to make change? Would you want to make change through the legislature? Well, who are we voting in? And if millions of people don't have the right to vote, the odds are stacked. So it's a wonderful point to raise. I think it should be a part of every one of these conversations. You know, by the way, just another part of this that I didn't get to mention, if you could just bear with me for a second. Yeah, I'm looking at my notes, and in the interest of time, I jumped over one thing, but I want to mention this. And I say this recognizing that, well, without knowing the backgrounds of everyone in the room, but I think it's important to say this. We have two bills in New York. One gives the prosecutor the power to seek resentencing. The other makes it mandatory for everybody. And some people I know very well, colleagues, friends, have said, you know, why don't you champion the prosecutor-initiated resentencing bill? There are some progressive prosecutors who've been voted in. And this is my response to that. We probably work with over 150 people. In every one of our resentencing or clemency or parole litigation cases, we reach out to the district attorney's office to get support. I think we've gotten support in maybe 5 cases. And what that makes me think, number one, that I think it's the wrong bill to vest that much power in a part of the criminal legal system that already has too much power. But that to me, it also raises the question of who's electing who and what does it mean to be a progressive prosecutor. And that if the more people were aware of this, who cared about it, then we might be electing different people who were truly, truly progressive.
I had a question. So I was curious about how you think these second look laws would intersect with people who have been confined under 3 strike laws that are in some states.
I think, you know, you should take a look at what Governor Newsom just signed into law in California, which I think addresses that very question. In New York, we have our version of 3 strikes, just isn't labeled the same way. And the deliberate intent of our second look bill, the one that the advocates are pushing, would just say that anybody serving any sentence, including life without parole, would be eligible to apply for resentencing after 10 years. So in a 3 strikes situation where someone was convicted of another crime and for sentence enhancement purposes ended up with a life without parole or a massive sentence, they too, after 10 years, would be able to apply for resentencing. To me, the most important part of your question is that any second look bill must not contain any carve-outs, such as for someone serving life without parole, someone convicted of homicide, someone serving a sentence due to a 3 strikes law. Just make it across the board and give everybody the opportunity to show that they've grown, transformed, and merit a second chance.
I don't see any other questions in the room. So I'm going to thank you once again, Professor Zeidman, so much for taking the time to join us today. Next time, you'll have to get up here to Vermont. We would love to have you. Thank you so much. This was really informative and, like I said, so inspirational and helpful to all of our thinking about this topic. So we're very grateful. Thank you.
Thank you very much.
Planning this conference for a Friday on our little remote campus in South Royalton, we didn't want to start too early, but we didn't want to go too late. So I want to just acknowledge that we've crammed a lot of substance into a relatively short period of time. So I appreciate everyone sticking it out with us. And I think this last panel is going to be as great as everything we've heard so far today. So first, I'm going to introduce the moderator and then welcome her up, as well as our in-person panelists today. And our moderator will introduce all of our panelists. Our moderator is Rebecca Turner. Rebecca is a lawyer here in Vermont. She is the supervising attorney for the appellate unit at the Vermont Office of the Defender General, and I asked her today, how long have you been at the ODG? And she told me 16 years. So she's been doing really important work in our state for a really long time. And the words that came to mind for me when I think about Rebecca are fearless and tireless, and the reality is probably that she's scared sometimes, and probably that she's tired a lot of the time, but to me, she is a role model of fierce advocacy. And so it is my pleasure to moderate our final panel of the day, Rebecca Turner.
Oh, Jessica Brown, that was lovely. Thank you very much. And thank you, the Center and VLS for hosting this incredible event. And I'm joined here virtually and in person. People who I am meeting for the first time just a few hours ago, and to who I am just meeting now here on the screen. But thank you all for sticking around. And it's been an incredible day for me, learning so many things. I think that our next panel and the perspectives here that we'll hear from next. I am truly honored to hear from their perspectives. We've heard a lot about second look laws, what they are, how they've unrolled in other jurisdictions, the science behind recidivism, and et cetera. Here, we're going to shift gears and talk to individuals with perspectives that couldn't be closer to the experience of incarceration, serving long imprisonment terms, or those who work closely with survivors of violent crimes. And so I ask these three individuals who have come through the pixels of far, New York, Washington, D.C., I believe, and here in Vermont, who's traveled from Pennsylvania, to introduce themselves and to give a brief sharing of who you are and perhaps to give us some landings on where you're coming from in this subject matter on Second Look and your personal experiences. Warren Allen, Brian Whitenhouse, and Kate Mogilescu. I will start with our Brian Whitenhouse. I'll start with you. You're here, and I'm going to come join you because I don't like standing, and I want to be a little bit closer here. So, Brian, thank you.
Thank you. My name is Brian Whitenhouse. I'm a person who has system impacted experience and benefited from a second look via the Supreme Court rulings on juvenile life without parole. Miller Montgomery. I served 31 years in Louisiana for a life sentence I received for a crime I committed 2 months after my 17th birthday. We'll talk more about the process, but just as an introduction, I've been released 3 years now. Shortly after my release, I was hired on with the Human Rights Watch to be a member of the National Life Without Parole Leadership Council, which is comprised of former lifers across the nation who are trying to use their collective experience through both going into the system and their redemptive path to coming out and overcoming life without parole sentences, and how we can use that experience to champion second look opportunities across the country. I am also, as of last week, a senior policy associate with FAM, a sentencing reform organization out of DC, who work a lot in second look legislation, but compassionate release, or a lot of stuff that touches on mandatory minimums. And the same day I received that promotion, I got married.
Thank you, Brian. Congratulations again. Warren Allen, I see you here. Oh, can you hear me?
Yes, I can hear you.
Oh, wonderful. Welcome, Warren.
How you doing?
If you could, thank you. If you don't mind introducing yourself, that would be wonderful.
Yes, good afternoon. My name is Warren Allen. I'm an in-life imprisonment campaign fellow at the Sentencing Project. I'm also a recipient of a second look. I was given a natural life sentence, well, 35-year life sentence. I was one of the individuals who was deemed beyond repair or forgiveness. During my time inside, I studied at Georgetown University. I became a leader inside the walls, someone who kept the peace. I was referred to as Black Love, specifically for that. I became a man of devout spirituality. Of that life sentence, I served 22 years. And when the Incarceration Reduction Amendment Act, or Second Look, was passed in Washington, D.C., I was one of its first recipients. I spent time and grew up with many people who benefited from a second look as well. And I'm here on behalf of nearly 200 people released on second look in Washington, D.C. In short, we are violent interrupters, elected officials, youth mentors, key staffers for organizations fighting for a better city and world, religious leaders, parents, and good neighbors. And the list goes on. But in short, thanks.
Thank you, Warren.
Appreciate
Kate Mogilescu. Welcome.
Hi, everyone. I hope you can see and hear me. Perfect.
Yes.
My name is Kate Mogilescu. I am a professor at Brooklyn Law School in New York City, and I'm a member of the Survivors Justice Project, which is an interdisciplinary collective that has, for the last several years, been working to implement New York's Domestic Violence Survivors Justice Act. And for those of you who heard Alexandra Bailey speak this morning, she talked a little bit about the Domestic Violence Survivors Justice Act in New York. The DVSJA is the acronym that we use, and it was a law that was passed in New York in 2019 and really represents New York's only second look or resentencing for people who are serving long sentences. You heard Professor Zeidman, he went through sort of the dearth of relief available for people serving extreme sentences. The DVSJA was, the campaign for the DVSJA was fought for and led by the Coalition for Women Prisoners in New York. a group that of currently and formerly incarcerated women. And the efforts around the law really began at Bedford Hills, our maximum security women's prison. And although the fight for the law took 10 years, as you heard from Alex this morning, the origins of organizing around the law go back even further. So we sort of trace it back to 1985, to a hearing that took place at Bedford Hills, organized by women who were able to see in their own experiences the connection between the violence they had experienced before their incarceration and their arrest, prosecution, and punishment for the offenses for which they were serving sentences. This led to the DVSJA campaign, which led to the DVSJA being passed in 2019. The DVSJA is a version of a second look law, but it is not a comprehensive second look law. Yet we have been using it for the last several years to try to decarcerate in New York as much as we can. Our collective, the Survivors Justice Project, is made up of many of the women who were inside fighting for the law over those many years, and women and men who have now come home through the DVSJA's provisions. So I can share more about kind of what we've learned and what we've been able to do with the DVSJA in New York, as well as some of the limitations and some of the things that have already been touched on throughout the day in terms of why robust second look laws are so important. But I think I'm on this panel, I'm not quite sure exactly why, where I fit in, but I think I'm here to also talk about some of the complexity of making this a binary of a person who commits an offense versus someone harmed by an offense, and recognizing, as the DVSJA does, that often that binary is not so clear, right? It's not so separate. And as we've talked about today, and as many of you know already, many of the people who are prosecuted for committing serious offenses have also experienced tremendous harm. But what do we do? What do we do with that? How do we hold both things? And how do we arrive at sentencing that is somewhat more reflective of that? Again, I'm not saying anything that hasn't already been raised today, but I think what we've done in New York over the last several years with this particular law can be instructive. I will just share quickly that 53 people have been resentenced after filing applications under the DVSJA so far. For those 53 people, over half were serving very long sentences for homicide offenses, the indeterminate life sentences that Steve talked about just a few minutes ago. Resentencing under the DVSJA has saved over 140 years for those 53 people from what would have been their earliest possible release date, meaning their first appearance before the parole board, their conditional release date. But if they had been sentenced in accordance with the DVSJA's sentencing framework initially, it would have avoided over 360 years of incarceration. So I think if you ask people in New York, some people will say the DVSJA has been not been utilized enough, which is probably right. But even if we look at those 53 instances of people getting sentence reductions, what can we glean from that? What can we learn? What can we learn about recidivism? What can we learn about the responses from people harmed in the offense, which I'm sure there'll be questions about? And what can we learn about kind of what we're offering as a community in response to harm? So I'll leave it at that for now, but thank you so much. It's really nice to join you all.
Thank you, Kate. You have a diverse amount of experience to share as well, and we'll get into those areas a little bit more later on. But for this first question I have, and I want to just go right into it because we've talked a lot about what Second Look does or hopes to do in terms of a sentence reconsideration. Professor Ziedman reminds us that when we talk about Second Look laws, that can span from clemency, right, to parole, to post-conviction relief even. But here we have Wayne and Brian sharing their own two personal experiences of sentence reconsideration, second look laws that come from different sources. And so, Brian, I'll start with you, and Wayne, this will also be a question to you, but how did the possibility of second look at your sentence impact your experience of imprisonment?
Well, when I was sentenced, there was no second look. There was no avenue for release. I often describe what people say, what is a life sentence? It feels like. I describe it as you're living in your grave, knowing that you're going to die right there one day. But there's always a hope that one day legislation can change. Clemency is on the papers, but too often underutilized and falls within political football back and forth. So it's not a realistic hope, but it is a hope. But you serve your sentence out day after day, year after year, just striving towards that hope. And Second Look for Juveniles started to come on the radar probably early 2000s. Most people don't know that, United States is the only country in the world that sentences juveniles to life without parole. And so there was a big movement to change that. And through the progressive rulings in the Supreme Court, eventually they outlawed it in 2012. Louisiana fought retroactivity. It was only given retroactivity in 2017. And even still, some people, opponents of Second Look, say, well, we can't do that because it would create too much of a backlog, too many cases. They'll get to you when they get to you. The day I became eligible for parole, it was 9 months later before I got my hearing because of that backlog. They'll get to you when they get to you. There's been some discussion also around the areas of victim opposition or victim positions on this. I was denied my first hearing for victim opposition. And it's kind of important that we talk about it. I'm glad that we're talking about it because I was mentioning to Rebecca, I have a pretty impressive prison resume and record, and the board essentially said, you have the best record we've ever seen. This is amazing. Denied. Well, what is it? You're denied because victim opposition. So again, I'm glad that we're talking about that, and I'm not saying right or wrong. It's something we need to talk about.
Brian, before we move over to Wayne and to talk about Second Look experiences with him on the inside through DC's legislation, you experienced Second Look through the U.S. Supreme Court changing the law on this nationally, finding it was unconstitutional, right, for juveniles to serve life without parole. And you talked about that turnaround time, about 7 or 8 months, and that you were denied your initial requested petition based on victims' opposition. Can you describe, though, the petition that you brought forward that made you a candidate? What were the considerations, or what were the details a little bit about why the board thought you were a good candidate?
Some of the things I've done, and there are a lot, it would take a long, but I was a lead facilitator, alternatives to violence, a long history of leadership roles in self-help organizations. I'm pretty sure everybody's familiar with the Chamber of Commerce, where there's a national self-help leadership development organization called the Junior Chamber of Commerce that actually has a prison division. So for 13 years, the chapter I was a part of and led was the #1 chapter in the nation. In 3 consecutive, but in 3 separate years, we won the national award for having the greatest impact on corrections. I've been a Red Cross instructor, kind of like a paralegal, the inside legal trainee. I have 3 vocational degrees. I wrote a grant to fund a prison arts program that was operating during the time of 9/11, and that art class, in response, did a commemorative painting for the New York firefighters to raise money for charity. We raised $35,000 for the New York firefighters. All in all, I think through the JCs, probably raised $135,000 for charity. And that's just some of the highlights that I can think off the top of my head. Very good disciplinary record.
But you are here now. So that first petition was rejected 7 or 8 months after the U.S. Supreme Court case law came down. So not such a long wait. what happened in your, was it the second petition?
Yeah, second petition was over almost 2.5 years later, which is fortunate. Louisiana, you get denied for parole, you can go back up in 2 years. Some states gave a response to Miller that you have one hearing. Well, if a person at 20, 25 years, you review them and they're not ready for release, what's to say in another 5 or 10 years they might become ready?
Did the victims in your case change their mind at that second review?
No, they did not. And, I'm very sensitive towards them, obviously. I took somebody's dear family member's life of them. That's irreparable damage, something I can never change or give back. I'm always gonna, be remorseful for them.
We'll come back to this question and this issue in another question. I want to get Wayne in here to share his experiences. Again, the question, Wayne, is how did the possibility of second look in DC impact the way you experienced imprisonment at the time?
Well, initially going in, just for, correct you, the name is Warren. You kept saying Wayne.
Oh, I'm
I thought
sorry.
another person was coming.
Wait, I'm sorry, Warren. Excuse me.
It's not a big issue. Initially, like as far as, DC, we're not, a federal, system. Therefore, most individuals who get incarcerated go straight to state. And when, Miller versus Alabama, was initiated, a lot of us was filing, for, once we came in. Well, not initially because, it didn't come about to like my 16th or 17th year of incarceration that I actually heard about it. But I did hear Brian say it was a thing since the early 2000s. But more importantly, it wasn't, a thing for us because every time we filed anything, we wasn't privileged to the law because we were state prisoners. We even with the crack law, the 18-1 and other things that was going around, gun laws and things of that nature, we wasn't privy to any of it. So once, Miller came out, we all had our hopes up high because a lot of us were juvenile lifers. Me and a lot of guys I know, we were juvenile lifers, spread it all over the federal system as state responses back, from the Supreme Court, basically like, this is not an issue for you all, but DC has something in place. We like, what does DC have in place for us? So, everybody was reaching out to local officials and things of that nature. I'm talking about basically the Incarceration Reduction Amendment Act, the law that brought me home. The DC City Council got together, came up with the bill, proposed the bill. It passed unanimously in Washington, D.C., and it actually became a thing in 2017. And individuals started to petition. And we still didn't think it was real because it's like, okay, you hear about a lot of bills and things of that nature that's being proposed that you can fit the criteria of, and you're constantly getting denied. You'll get denied before you get granted anything. For those who've done time, can express that to you as well. So, however, a couple of my friends petitioned. One of them actually made it home, so we knew it was a thing. Like, this is really, really happening. So we just had to understand what were the provisions, what are the things that the court is asking. The court is asking you have to be 17 years of age or younger. You will have to have caught your offense in Washington, D.C. Some of the other things to meet the criteria was that you couldn't actually you can petition 3 times. If you were denied your first time, you could petition 2 more times. So that was a good thing. As far as like programming and education and things of that nature, those was a lot of the requirements because quote unquote is supposed to be a rehabilitation bill. So some of the things that the judge is more so looking for who is the person that you've become. How far away are you from this person who was sentenced to a 35-year life sentence, right? So, the judge went in, based on a lot of those factors, your education, certain instances, your institutional record, far as the shots and things of that nature that you was catching, the judge paid close attention to that. Definitely victim impact statements was definitely something that the judge paid attention to as well. With all that being said, after this clinical review, we had mitigation specialists. Some of us did. We had investigators as well. And more importantly, in a lot of our cases, our mitigation reports actually soften the understanding to the judges, because a lot of us come from something. A lot of us didn't have first chances, let alone a second chance. So basically coming from, not humble, disgruntled beginnings, poverty riddled neighborhoods and things of that nature, shuttled into, prison, basically prison, the school to prison pipeline. I was actually a victim of that. So I do understand all these proponents of that, but moving forward, second look was something that the judge more so looked at it from a fundamental basis. If an individual showed fundamental change throughout his incarceration, did he program? Did he educate himself? Who he's become today? Can I stand next to him in the grocery store? These are some of the things that's going on in the judge's mind. Who are some of the people that's, in the community that's coming to speak up for you? Who are we releasing you to? Who are they? A lot of the things is highly scrutinized. It was not a get out of jail free card by far. It was not to get out of jail free card by far. And a lot of the judges, they were cohesive, and that's what made it a smash hit for Washington, D.C., right? And I'm here to say over 200 of us are home now. I think on November 11th, 13 of us, we going to see Cat Williams. A lot of the guys who came home who are out free, and things of that nature. We are out, we're everything that, we know we could be, and we are redeemed.
Thank you, Warren. You talked about DC's legislation giving you 3 shots. Is that right? If I heard you right. Yes. Is there
DC
just... Brian's talked about in Louisiana, they had required break in time between denial and repetitioning. Was that the case in Washington, D.C.? If you were denied the first time?
Yes. 3 years was the max. You wait 3 years, get a little time in between it. If there was a case where, the judge say, well, you're on the right track, you're showing the right programming, you're showing the right education, but I want you to show a little bit more of this. In certain cases, the judges did rule, did deny individuals who were on the upward trajectory. And but that's all the case of what judge you're in front of. But more importantly, it's 3 years. It was 3 years before you are able to petition the court again.
And I think I heard you say that in your experience, there was room for victims' rights impact statements in the petition process or the review process. What else, or in what other ways did victims were they involved in your petition process?
Well, like initially, like once you up for review, the court reach out to the victim family and let them know that, look, this individual is up for review. He's coming up for a second look. This is the person that he's become. Here's a letter of remorse amongst many, because I was an individual who started a program on the inside to write letters to families who've been victim of violence. But my lawyer reached out to me and staff there said I couldn't do that because that's a breach. And so I'm not just saying this just because, but I was one of the individuals who initially had remorse. But however, the government reaches out to the family of the victim and let them know that you are up, for review. And if they want to participate in it, most of them do. Some of them can come. Well, the ones that do, they come and they testify, at your hearing. Some say yay, some say nay. I don't set in hearings where, I've heard mothers forgive, sisters forgive. And I also don't see it the other way, right? And and sometimes when you can understand an individual's hurt, you don't press too hard on that. You understand what it is, give remorse the best way you know how, and just try to move on. But I think that process, I think I think the system has failed that process because they're not connecting the victim and the offender correctly. It can be some sort of communication there, some sort of what I call some sort of intervention, some sort of connection, so it can be a better level of communication and understanding.
Thank you, Warren.
Yes.
Kate, I'm going to bring you into the conversation, and you talked in your introduction about how we often talked about victims in a binary fashion. We've just heard Warren and Brian talk about the role of the victims in their second look petition process. I think the question for you is, what role should victims have in this process of second look? And sort of layered in that question is what do these long sentences serve for victims? What do the second look review processes provide for victims, survivors, if anything? I think I'll stop there.
Yeah, I think those are very big questions, and so much depends on how a law is sculpted. So I can share what has happened with the Domestic Violence Survivors Justice Act, which is, again, a very limited second look. It is a second look where the person prosecuted can show that they were a survivor of family abuse, and family abuse beyond just intimate partner violence, abuse from family members like other than romantic partners counts under the DVSJ, and that's an important distinction for all the reasons we've been talking about in terms of what people experience prior to committing an offense. But under the DVSJ, you have to show some connection between that and the offense. Now, that seems rather intuitive, particularly given everything we've been talking about today and heard today. But it is, a burden that people bear when seeking resentencing under the DVSJ. So it is not 100% about rehabilitation in the way that some other second look laws might be. There's a sort of second element, which is you have to also prove that you are a survivor of domestic violence and show the connection to the offense that you committed. Then all of these things that we're talking about in terms of, has someone been rehabilitated? What's the public safety dynamic here or consideration? The language in the DVSJ is that the court needs to find that the original sentence was unduly harsh. So what does that mean? It can mean a lot of things depending on what judge you're in front of, right? But the role of victims is not specified in the DVSJA. So it is not mandated that anyone impacted by the offense has a right to participate or a right to speak. Our general, crime victims Bill of Rights indicates that prosecutors have to notify people at certain stages of a proceeding. But what we have seen in practice with the now, more than 100 applications that have been filed is that a lot of this is left to individual prosecutors to figure out what the role or input, how the input of the people who are maybe harmed by the offense should be incorporated into the resentencing application. And someone this morning, I think it was James Ziegler, said, prosecutors hold on to that power very tightly. They speak for victims, even though they're not the lawyer for the victims. They're the ones that communicate with victims. They're the ones that have access. And I think we've actually challenged that quite a bit under our practice, under the DVSJ. In many of the cases that we work on, the people harmed were family members of a person. So it's not that only the prosecutor that has access. Of course, there is tremendous pain, right? And grief and many other things layered on, but it sort of breaks from that situation where a prosecutor is the only one who can speak to a victim about, their perspective on resentencing. So oftentimes, and I think this was also addressed in the chat, there were people in the chat who were kind of mulling this over, we, as the lawyers for the person seeking resentencing, as the legal team for the person seeking resentencing, reach out to the people who are impacted and harmed by the offense and have some of these conversations. I think it's something we all could focus on a lot more. When is the right time to have the conversations? Who should be part of them? And who has power and controls the structure? All really important questions, I think. What we have seen with our DVSJ resentencings is that, and I think, again, Warren just said this, some people who are impacted by offenses are open to resentencing. Years have passed, they haven't found healing, and they haven't found healing by knowing the person who committed the offense is in prison or still in prison or will be in prison a certain amount of time, right? Some people have found some sort of healing and see it and understand it as detached from the term of incarceration in terms of months or years. Some people have an incredibly high amount of frustration, anger with the courts and prosecutors because they also felt silenced in the initial prosecution of the case, right? As much as the person being prosecuted is silenced, can't accept responsibility, can't say many things that often people need and want to say, right? Because lawyers are constantly saying, you can't say that, it's going to hurt you. You have to just sit there. Other people impacted by the harm are also silenced in the process. And so that leads to a tremendous amount of hostility, anger, frustration. So we hear that years later also. And then, because again, we're talking about domestic violence and its connection to offenses, and a lot of the times where someone harmed in the offense was not an immediate family member. So in some of the scenarios even that you've heard today, you know, where a robbery gone bad, which turns into a felony murder prosecution for several individuals, right, where it's a stranger that was harmed, when a victim's family learns more about the person who was prosecuted years ago, learns more about their background, learns more about what they had experienced, they take a different position. All of these things are possible. In addition to, as Warren said, some people coming in and saying, no, absolutely not. I haven't changed my position. We have to leave space for all of it, and none of it can be determinative of who stays in prison and who doesn't. There's space for it, but it can't be determinative. So what should we do? We need to think really hard, and this has come up in so many points throughout today, of what other points in the process can we also create that space, recognizing it's not a one size fits all. And because of how grief and pain and trauma operate, there are many points in which people may not actually be ready to engage. But when they are, what can we offer them? I don't know if that answers your question exactly, but I did want to also respond to something Warren was describing about the second look in DC, which is when the DVSJ was passed, even though the leaders of the movement to get the law passed were people who were currently and formerly incarcerated, there was still a lot of skepticism inside that this was actually going to work for anyone, right? People had just become so conditioned to being disappointed by the legal system that it wasn't until, as Warren said, the first person that was really resentenced after kind of making their robust application that people began to feel hopeful about this law. And it led to many conversations inside along the lines of the same conversations that actually were the impetus for the law and the legislative campaign. People seeing someone go through the process, get their sentence reduced, leading them to reflect on their own experience, share with others, right? There was like sort of a ripple effect inside that also was healing and worked to reduce the isolation that many people feel in prison. So I just wanted to mention that as well.
Thank you. I want to shift now a little bit, going to something that's come up throughout the day, and that's linking sentences imposed after conviction with accountability. And perhaps the questions in many people's minds as to whether or not second look at the original sentence imposed sort of undermines this idea of being accountable for the underlying crime. And during lunch, I was talking with Brian about this idea of what accountability in his specific context in terms of the crime that he was convicted of, served his lengthy sentence on, and then received second look, release on parole. What does that mean to you? And when you hear about concerns about second look legislation as undermining accountability, what do you want to share about that?
Right, so accountability is up to the individual. Being somebody who did 31 years, I can sit here and tell you, this is what I saw. Not opposed to this is what I think or theorize. So in my own situation, I took accountability right away. I felt the weight and the guilt of my crime almost instantaneously. I was sharing with Rebecca that, I committed my crime with this, in my juvenile brain and irrational thinking, that I had this morally righteous justification. And as soon as I committed the crime, shocking reality almost crushed me. Like, what did you just do, and why did you do that? And that's just the fog of the juvenile brain, I guess you can say. But I went into prison knowing that I took a life and that I needed to change myself. I needed to give back. And so I threw myself into every program that was available, every self-help, and I tried to help all people around me do anything and everything I could. And I had the mentality that if I died in prison doing it, it's well spent. And it's the right thing to do. Fortunately, I did get a second look opportunity. But as I said, I can tell you what I saw. And that's not the case for everybody. There's a lot of people in there who don't take accountability for their actions. Won't care, could care less about going to programming or bettering themselves. If they had a determinate sentence, they're just doing their time till that date came. If they had a life sentence, a lot of them was like, why do I need to do the programming? Why do I need to go to school? What's the point? We're going to die here anyway. It's useless. What's the point? I don't think that second look would diminish accountability in any way. I think a lot of times it will promote it. We're seeing reports from correctional officers in various places where second look is starting to take hold, or specifically in Louisiana, where our governor is currently pardoning a lot of people with life sentences, and the correctional officers are reporting violence is drastically down, participation in programming is way up.
So if I'm understanding, second look creates sort of incentives or
I would say, yeah, it incentivizes accountability. If not so much accountability, to a degree, probably accountability, but more so self-improvement and rehabilitation.
You've heard about sort of the barriers. We've just talked about, Kate just talked about the barriers of being able to be accountable directly with the victims involved in your case.
Yes. We did, and it was mentioned earlier in the program about apologizing in some situations. So in my situation personally, as you go through your trial and you come to the sentencing phase where you have an opportunity to speak, most people aren't aware of this, but your lawyer is going to tell you, do not apologize. We're going to appeal this case, and if you apologize, that's an admission of guilt. So you go through that, and you go through many years of appeal processes where, you cannot apologize. And in my state, particular, Louisiana, where I was, it's against the law for me to even approach or try to make contact with the victim. Not only myself, anybody in my family were to approach my victims, they could be jailed and potentially fined or jailed. And so what happens is you can do 20, 25, 30 years, and you get to a parole hearing and the victim's like, he never tried to apologize. If I could have, I would have vehemently. Thankfully, the parole board members said, ma'am, he's not allowed to. So it is a barrier that's in place, And I think if we are talking restorative justice, which is trying to focus on the victim's needs and restore the justice between the community, the offender, and the victim, that we need to find ways to work on this issue and not have this adversarial system that prevents this type of healing and progress from occurring.
Warren, do you have any thoughts to share on this question as well in terms of the question of accountability and concerns that second look and revisiting your sentence imposed somehow undermines accountability concerns?
Yes, I say when I committed my offense, I didn't understand what accountability was. Right. So it was no way for me to be accountable because I wasn't educated to it. I had to understand what accountability was, through growing, learning, understanding. Right. It was nothing that you can say. Being accountable shows in your action. Like, who are the individual that you're going to become? Right. Are you trying to fix yourself with some of the things that was going wrong? Like, going into the institution, I think I had like a 5th grade reading level. I left with a college reading level. So, I had to grow, I had to understand things. And that's the biggest, I say, divide with individuals accepting, the responsibility to those who not. A lot of people coming from backgrounds of trauma, and most of the individuals that commit these crimes are victims themselves. And how they say hurt people. So you get into an environment, you understand what your crime was, you will be, kind of remiss not to, be hurt about it. So I was definitely hurt. I was troubled. You start to understand certain things about life and being loved, and hurting and harming people and finding ways to communicate that to them. So I had to become educated to understand how to communicate that to people. So my remorse came through my actions, programming, becoming a tutor, helping those out in the environment I lived in, becoming, like a liaison in the community. When I was incarcerated, one who was, called upon when, things can be going a little left institutionally. Administrators would call me, not that I was personally working with them. The inmate population, excuse my language, the resident population understood who I was as an individual. So I was a good person, to mediate and things of that nature. So through that process there, that's when I became, more, I say accountable, because I understood that it's something that I have to invest to become accountable, not something that I can say. So for those who haven't, for those who don't, certain individuals, you know, just don't get the aspect of, like, let's say, for instance, I say I'm accountable for this. Will I get a second chance? Will I get a lawyer to take my case? But it's more so this here. You're locked up. You have no other way to get out. Desperate times call for desperate measures. Most of the individuals know they are guilty, would love to say that they are guilty, but by them saying they are guilty, will they ever get out of prison again? So Second Look was perfect in DC due to the fact because individuals was able to express their remorse, not only through letters, but through live testimony and hearing. And certain parents embraced it, others, didn't. But what truthfully defines if a person is remorseful is basically his actions. Who have he become? Have he educated himself? Do he have a spiritual connection? Can he again be trusted at the gas station at night? You'll start to see certain things within a person to know that he's remorseful. And sometimes once you're dealing with a parent or relative who have lost a loved one, again, like Katie said, it is hard business, and it's just something you have to understand. But more importantly, initially when individuals go in, like Katie said, a lot of parents or loved ones hold that hate because they didn't get the chance to express what they truthfully wanted to express. So as it get a little later on down the line, like bingo, here's my time, and most of them come in with that energy. But not to be more so long-winded about it, but my experience is that when an individual is uh empathetic, remorseful, whatever word you want to use, it'll more so show in how he rebuild himself.
Thank you, Warren. Kate, do you have anything you want to add to this question?
Yeah, I think that one thing that we struggle with, or we think a lot about at the Survivors Justice Project, is how these terms like accountability and remorse are really have become performative, and who gets to decide, right? And who gives the right performance. And there are, of course, a lot of dimensions to this. We think about the power that judges have in this way to look at people and think they know anything about who's remorseful, who's not. I mean, right, there's actually research about how bad judges are in assessing remorse, how so much of it is racialized and gendered, right? And this performative thing that just is imprecise at best, but somehow governs everything, hangs over everything. These words like accountability, in our criminal legal system, we've been trained that accountability just means a certain number in terms of years of a sentence. And we have to do quite a bit to move ourselves away from that notion. Like, when Steve said over lunch, if you go into any courtroom in New York City this week, you will see a young person being sentenced to an indeterminate life sentence. We haven't moved away from the notion that somehow is what accountability looks like, rather than all of these other things that we're talking about. And quite honestly, judges, prosecutors have not spent a moment in prison, to see what it is like, to understand what they're actually sentencing people to. And I suspect that if they did, their view may change, and not just the sanitized tour of the prison that's handled by the superintendent when an important government member of government comes through, but what it's actually like. We do a workshop called The Trauma of Incarceration. The Survivors Justice Project has put it together for domestic violence organizations that want to serve criminalized survivors, right? Survivors who have been in jail and prison, but don't really understand what the additional layers of trauma that incarceration can cause for people. So then when you get to this question of performance in a second look application, performance in front of a parole or clemency board, right? And you hear it all the time. There are so many people who have done amazing things inside, right? Gone on to earn multiple graduate degrees and all the things. But that's also then performed on the outside in order to get this result. And what about people who are in states where there are no prison education programs?
Mm-hmm.
There is no mental health services or therapy, right? And so what happens then? And so I think in some ways, yes, we want to highlight all the amazing work that people are doing inside, often under really, really difficult circumstances, but we don't want that to become required in the way that then it's weaponized against people that aren't doing that. If we as a society are saying these sentences are too long, I wonder then how we can kind of reach that without exceptionalizing these great lengths that many people do go to inside, and then kind of casting aside many others who might be left behind. So it's an open question for us.
It's a perfect segue to my next
Can I
question.
add something to that? Can I add something to that? Because Katie said something that was very, very important. I have seen in certain instances where individuals came in and stated their innocence. And then once the Incarceration Reduction Amendment Act came around, they are still stating their innocence. But most of them are scared, literally to say, I didn't do it, because they believe they'll get denied. And again, it does create an adversarial system. And some individuals, just say they did it just to get the review and go home, because their record suggests that they did enough to fit the criteria of Iowa. But I just had to add that. So, the biggest question is those individuals who, let's use the word accountable, didn't take the accountability. Um, well, was not accountable initially due to the fact because they believe in some shape, form, or fashion that they were innocent, right? And they still feel the same way years later, whether it's by technicality or what have you. I don't know, but yeah, I just had to add that.
Oh, thank you. There was a question posed during the keynote address, question comment, which I want to raise here, which is the importance of getting the voices of people who are actually impacted by the experience of lengthy terms of imprisonment. The voices, and here I turn to my panel members, the question to you, which is what we've been grappling with a little bit all morning, certainly what the pending legislation in Vermont is presenting, which is what should second look like in Vermont? And so I asked the question to you who have gone through the process. There is a proposal of what factors should be considered to warrant second look reconsideration of a sentence. Can you share with us what you think are the relevant factors that should be taken into consideration?
Well, obviously there's some. You're going to look at what did the person do from the time they were incarcerated. Too often, though, when we have these reviews, it's almost like they're retrying the case. And we need to get away from that. We need to judge merit a release based on what you've done since you were sentenced and the effort that you put into your own personal rehabilitation. It could be education, self-help, mental health. If you have substance abuse issues, you should have been participating in substance abuse programming, all these variant factors. But it also comes down to the very last thing, and I mentioned this to you, whether it's a judge or a parole board, I feel pretty confident in guaranteeing you that they're not going to roll the dice. They're not going to say, you know what, this person might commit another crime, but we'll take a chance on them. No, they're going to deny that person. They're really only going to grant release to people that they're confident who no longer pose a threat to public safety and also present a no longer need for incarceration. I think that's what second look law is. And a lot of time people hear what it's proposing and they think, oh, it's just let people out. What's to let people out who need to be let out or should be let out, and those who aren't ready or have issues that need to be worked on or pose any threat to public safety, guess what? They remain in. My time in incarceration, we've always, as prisoners, we were always hoping that something would arise to cause some kind of relief for us. And it usually happened with budget deficits in the state. They're going to have to cut prisons. And during my time, what they did was they just grant extra good time. They really just cut sentences. Nothing based on review, merit, or anything. Just cut some sentence off. Well, that's a terrible approach. Second look, you can't get a better idea of reducing prison populations and addressing some possible injustices, because one of the things when you have a very harsh system of justice, it's inherent that you're going to have some injustices in it. That's the beauty of this. It's a second look. It's just a reassessment.
Thank you. Warren, do you want to jump in and make some suggestions on what should be factors in consideration to getting a petition granted?
Yeah, sure. Brian hit a lot of things on the head. But I'd like to add, some environments that individuals are incarcerated in are very, very hectic, right? And it's very hard for an individual to go through that infraction free. I believe environment should play a huge factor on the individual's hearing. Why? Because if you're in a low security institution, it's not going to be as much violence as it would be at a medium or a high, you know, and that's just what it is. I lived it. I lived it to know it. I've been on all three levels. And sometimes once you're in the higher levels, you know, the politics is real thick. And upon review, you know, some individuals might have a couple infractions. It may be a fight or it may be talking back to a CO, but please take into account the stress that an individual is under on a daily basis in those type of environments. And just for a person just to have an argument with a CO, it could be written in more of an attack form. Like they will attack you on paper because they know this will hurt you, get you the infraction. This can kind of eliminate your transfer to a lower security institution. So they use infractions, you know, basically as bargaining chips. But I think that would have to be looked at also, you know, as far as, again, you know, Katie spoke about the programming. In certain institutions there's no programming. I've been in institutions like that, little to none, you know, and we had to create our own programs. And you know, in certain, well, second look do ask for, you know, an individual to show his education and program history. But what do you do when the institution don't provide it? What do you do? You know, so that's another thing that need to be looked at very seriously, because I have a few friends now that call and be like, look, man, we here at Big Sandy, you know, we always locked down. Um, they ain't bringing in no self-help books or, you know, anything to, you know, help them while they behind the door, because that's a high security prison. You know, a lot of stabbings and things go on there, so they constantly locked down. So things of that nature have to be taken into account, you know, because every one situation is different. Yeah, we all, you know, again, fighting for the same thing, but the underlying things are very different as far as location, um, you know, offense, you know, and other things. But that should be looked at. And lastly, uh, I say um, a person mitigation record, right? Like, who was this? I mean, did he just jump off the porch and start committing crime, or was some things going on in the household? You know, was he touched the wrong way? Did he have a proper meal leaving out the house each and every single day? Because certain circumstances turn individuals into negativity, and some of them things need to be, you know, recognized, because I know I went through it, and I have a few friends who did as well. And now we all out here living life like it's golden. But those are three those are three of the things that I believe that um should we should take a stronger look at.
Thank you, Warren. Kate, I'll let you have room to jump in too, to add, and I realize the order of this, you're coming in last, and I'll throw the next question at you first to switch up the order.
Oh, no, it's okay. And I know we are close to time, and people have spent their day kind of thinking through a lot of these questions. I would say that the draft of the Vermont statute has a lot of really key factors in it. It allows a consideration of age, of prior circumstances, prior abuse, of current age, current medical conditions, prior lawyering, right? One of the things that we haven't even really talked about is just the crisis and the quality of lawyering that people have. Certainly not in Vermont, I'm sure, but everywhere else in the country, where, right, just the quality of representation is abysmal for people charged with crimes who can't afford an attorney. Even those that can afford an attorney, the quality is not so much better often. But I digress. So thinking about how that factors into outcomes and sentences, that's in the Vermont bill. It seems really important. All of this is key. I think something I just mentioned before, I would say that if this effort is successful and you do get a second look bill passed, the judges need training on all of this stuff, and training that really forces them to reckon with the concepts that we've been talking about today, and a training that could look like going into a facility and sitting down with a group of long-termers to learn how prisons operate and some of the things that people contend with, so that when you look at a disciplinary record, you know, as Lauren said, you have that context. You understand. It isn't just an automatic. So I think that that's really important as well. And when the Coalition for Women Prisoners in New York was working on the DVSJA, which was, again, a very long process of back and forth, the women inside the organizing group inside Bedford Hills, there was actually a nun named Sister Mary Nerney who worked for a community-based organization, and she did a lot of work at the facility, and she would bring in copies of the drafts of the legislation to the committee that was working inside, and it was actually contraband. She wasn't allowed to bring it into the facility, but she got it in because she was a nun and the officers didn't really mess with her that much. But she brought these drafts in, and the committee would go over the drafts in the same way that I imagine is happening in Vermont, and just kind of agonizing over every provision, every detail. And the one thing that people were really committed to was to eliminate or decrease as much as possible offense exclusions. You've heard it today, right? That even people convicted of the most serious offenses need an opportunity to pursue second look relief. It is not automatic, right? Courts, this is not everyone walks out, nobody's vetted, nobody's nothing. Courts have the ability to say no. We don't want them to, but they have the ability to. But by excluding certain offenses from consideration, we do a lot of additional harm. So I would just add that as well.
Thank you, Kate. Jess, I don't know if we have time or are we out of time for questions? 9 minutes. Oh, wonderful. Look there.
Thank you so much for all of your sharing. A question that I have, and not to detract from the important work that folks working on second look legislation are doing, and not to take away from the focus. Something that I'm thinking about is that, kind of paradoxically, something that has come up a couple of times today is this idea that second look legislation is really rooted in this logic that people can and do transform, right? And that people can and do transform in prison. And so, somewhat paradoxically, I think that there is perhaps a caution, or I have a bit of apprehension that someone might walk away from a conversation or some brief encounter with conversations on second look legislation with the notion that prisons are transformational places. That's not to say that transformation doesn't happen in prisons. That's absolutely true. But that prisons are perhaps positive forces of transformation. And even the long sentences that second look legislation ostensibly is trying to combat are positive forces for transformation. So I wonder, what do we do with that paradox? How do we combat it, as we push for this?
Thank you. Does anyone want to jump in and respond?
I mean, I can try. It's a really important question. It's like, how is all this not somehow legitimizing or reinforcing the notion that prisons are doing good and doing the thing? So one of the first resentencings that we had in New York under the DVSJA was a person who was sentenced to 25 to life as a 16-year-old. And the DVSJA applications have to go back in front of the same judge that imposed sentence if they're still on the bench. And so there was a lot of concern about that, right? This was useless. The judge gave the maximum after trial many years ago. Why would the judge change their mind now? And to spoiler alert, the judge did change their mind and ultimately agreed to resentence this person. The person was released immediately. I have to believe that that judge may hesitate before imposing that kind of a sentence again. Is it off the table? No. But I think that, and Steve said this over lunch, right? Judges don't have the ability to see kind of what happens with people after they're sentenced. And this brings information back to them. Does it offer a somewhat sanitized and romantic view of prison? Maybe. And I think it's a danger. It's a real danger. How do you tell a story of someone moving forward and growing and learning and doing all these things without somehow buying into that? But I have to believe that with each resentencing, we are showing judges, prosecutors, those that hold power, another view. And so maybe it's that, okay, instead of 25 to life as an initial sentence, I'm going to think of that case. That case is going to be somewhere in my head, and I'm going to just start at a lower point. I don't know. I don't know if Warren or Brian have more ideas about that.
I just say that, the brain science is real. You can be at a place, that's not conducive to you and your likes or your wants, but naturally, we all evolve and change, you know, under circumstances, good or bad. And as an individual age, the more conscious they become. The scientists is weighed in, so the things that I'm saying are true. When you are in an environment, that's, built to do one thing, but the thing that is built to do, it definitely contradicts it. The narrative that's put out, oh yeah, prisons for rehabilitation, this, that, and the third. However, it starts with the person, right? Because certain individuals can hit the ground running, go to GED programs, kind of, set themselves up, in an environment where, they believe they can do a sentence or something here to more so show the courts, how they've grown. But in other cases, individuals wait a little longer. So, the paradox is that it's only believable when it's on record, right? Because if an individual don't see it, and Kate just hit the hammer on the nail. The judges sentence you, but they don't see the things you're doing after your incarceration. Then you bring it back front and center, and you have something on record. This can or may not be true about this person. Certain individuals get in, find positive ways to do their time because there's nothing else to do, and just so happen put themselves in a position to like it and go home. But definitely a tough question. But the best thing, I can sum it up with is that the brain science is real. Individuals naturally change, and Miller versus Alabama is predicated solely on that. And that's the reason why I'm home today. That's the reason why Brian's home today. And look at me, I'm out here flourishing, and it's a beautiful thing.
Yeah, I would just add, and I know there was another question. To me, that is one way to look at second look, is that you cannot reconcile the harm that incarceration causes separate from what happened before. But fundamentally, second look allows you to drop down and revisit and reconsider and fix mistakes, or allow for what Warren just talked about, what new things, advancement of the human knowledge and understanding science, to now inform us to review and actually reconsider a sentence consistent with our current social and norms and our best understanding of science. So do we have any time for any more? No, I'm hearing no. Oh,
One
yes.
more question. My question's for Kate. I think the DVSJA is a really limited application, but a really good foothold for this second look legislation. I'm wondering if you can talk a little bit about what the first conversation with the harmed party looks like when you're starting this process with the survivor themselves.
Thanks. It's a question I wish I had a really polished answer to. It has been a learning experience. I'm a public defender. We have no training. We've had no training throughout my career in this exact question. And in most of my trial level work, we didn't do this, right? We were sort of again, kept separate. Like everything's so separate, and the prosecutor talks to these people and we talk to these people, and everything is adversarial and different. And I think the DVSJ allows us to break some of that down. So we are doing it. We are doing it probably inartfully. Our sort of ethos is to not cause additional harm and to be as transparent as possible about who we are, what we're working on, and that there is room for all of the feelings and emotions and responses, and we normalize that for people. And then we also, right, with the people that we are working with to try to get sentences reduced, have to kind of absorb whatever the reaction is, because it can bring up so much stuff all around. So what I would advise is to go down this road, have a good interdisciplinary team that has expertise in trauma, in sort of grief and grieving, and can help, can absorb on all sides. I'm doing this also alongside law students who are kind of struggling to develop their own professional identity and approach. And so there's just a lot of growth all around with each time we have the conversation. I will say that we don't have it at the beginning of the process, right? So you said when you start to work with someone, we are usually very well in, and our DVSJ resentencing applications do take quite a bit of time to put together, because they are this whole backward looking, and it goes a little bit beyond just what the person's experience in prison and record in prison has been. It's looking back at their experience with domestic violence. So it is much later in the process of working on a resentencing application that we start to think about outreach to people who are harmed by the offense. And again, in many cases, the parties are well known to each other and the families are still very much connected, because that is the intimacy of a family, regardless of whether harm has occurred. In some cases where the harmed person was a stranger or not known, it's a little bit different, but we are working through it. And again, I think we could learn a lot here, more than we already have. And I would welcome a chance to talk to people who are doing similar things and think about what we all need to support each other as we have these conversations.
This has been a great way to end the day. Thank you to Brian, Kate, and Warren, and Rebecca for an excellent final panel. Thanks to everyone who joined us online and in the room. If you registered, you probably already have received an email from Cora with an evaluation in it, so we would love your feedback. If you are here on campus and you have a badge, please leave it on the table because we will recycle it. Thank you to Brian, Bill, and Rachel for the seamless technology today. Woo! They are probably off working on some other event, but thank you to our cafe team for the delicious food and to B&G for getting the room set up for us. I just truly can't thank the participants on our panels and the National Center team enough for the fantastic conversations, information, education, and just experience of this day. I'm really, really grateful. So yeah, thanks all for being here. Get home safe.